would not like to mention, but I have to. The reason is, there was a Bangalore Palace Acquisition and Transfer Act of 1996, upheld by the High Court through legislation with a compensation of 11 crore. Just a minute.
Send your letter.
No, these says I will not allow. That's why I'm giving the reason. So, 11 crores upheld, appeal pending since 2003. In the meantime, the government wanted to have a public road, for which TDR rights have been given of 3,000 crores.
Just send a letter.
I've sent a letter. He says, because it's a civil appeal, I not allow you to.
Pending matter.
Yeah, it's 2003. Since
okay, fine.
97,
Send a letter, please. Send a letter.
Very right. We have to implement it in 6 weeks, the 3,000 crores.
Please send a letter of request, an email or a letter of request. That's all. A letter of request to Banavar. Wait, let's start now.
We need at least 2 days for this.
Please, we'll see.
We'll
see.
There is one batch of candidates who are untainted, selected, not found any.
Please. Let's not have piecemeal arguments. Let's start.
My Lord, should we are the state first and the commission first?
I don't know. Whoever wants to start, let's start.
We are students, we are the people.
1 minute, please. We said on the last state also, you decide who wants to start.
The state has been starting. Normally the state starts earlier.
Okay, fine. These two will start this thing. You are paying for the state.
No, I'm not for the state. I am saying the state has been starting. I am for the untainted category.
Limited prayer, Millet. State has a limited prayer. Millet, we are the affected candidates. Therefore, Millet.
Okay, whoever wants, let the state start and then the other states.
We could respond in advance. Notice whether 65. The state has advocated before the High Court that no segregation can be made. It is so colossal. That para 265 is the judgment is the
Okay.
state.
Okay, please. Yes, please. You're preparing for the...
I'm appearing the state.
Because if the Lordship has the order of this court, my Lord, the data, 7th May 2024. That sets out, my Lord, in some detail how the matter comes up.
Yes.
May I place this order?
Please go.
Paragraph 3, Mills. In 2016, the School Service Commission in West Bengal conducted selections for recruitment to 4 categories of posts. Assistant teachers for class 9 and 10, assistant teachers for class 11 and 12, non-teaching staff of the Group C category, and non-teaching staff of the Group D category. Notification for the state level selection test was issued on 16th February 2016 and OMR-based written examination was held on 27th November 2016. The final panel for candidates for class 9 and 10 was published on 12th of March 2018. The merit list of impaneled candidates was published on 28th August 2018. Candidates joined as assistant teachers in or about January and February 2019. A batch of petition was instituted before the High Court challenging the selection process of 2016. The selection process for assistant teachers was governed by West Bengal School Service Commission. Selection for appointment to the post of teachers for class 9 and 10 in secondary and higher secondary schools, Rules 2016. Likewise, there are rules governing the selection to assistant teachers for class 11 and also of 2016. The selection for Group C and Group D non-teaching posts is governed by West Bengal School Service Commission, Rules 2009. The writ petitions before the High Court was instituted in 2021. From time to time, interim orders were passed by the High Court annulling the appointments on the ground that appointments were made illegally. The appointments were held initially before the division bench of the High Court and ultimately to this court. By its order dated 9th of November 23, this court held that the direction of the High Court for the termination of services of candidates at the interim stage, even before the final disposal of the petitions, ought to have been avoided. This court, while dealing with a batch of petitions directed in Achintya Kumar Mandal versus Lakshmi Tunga, that all the issues relating to the appointments of 2016 should be examined by a division bench of the High Court, and accordingly, an order of remand was passed. The issue of maintainability of the petition was kept open. The order of remand has resulted in the impugned judgment of the High Court. The High Court has held inter alia that all appointments made in the selection processes involved were violative of Article 14 and 19 of the Constitution and are therefore null and void. As a consequence of the judgment of the High Court, approximately 25,000 appointments will be set aside. During the course of the hearing of the cases before the High Court, there was a direction to the Central Bureau of Investigation to conduct an investigation in regard to the alleged acts of criminal wrongdoing arising from the selection process. The order dated 9th November 2023 directed the CBI to complete its investigation within 2 months and to submit a report of the High Court. In the meantime, this court directed that the appointments which have been made shall stand protected for a period of 6 months to enable the division bench to adjudicate upon the matter. Before the High Court, as indeed before this court in the earlier proceedings, a fundamental issue which arose for consideration was in regard to the admissibility of the OMR sheet images which have been recovered by the CBI. The court noted that the investigation by the CBI has yet to be completed, the admissibility of the OMR sheet images being in question. This court observed that the question of the exercise of power in relation to discovery of electronically stored OMR sheets implicated serious allegations in regard to manipulation of records. Having regard to the number of persons who are likely to be affected by the outcome of the proceedings, it was considered appropriate to remand the proceedings back to the High Court for final decision on the writ petitions. Before dwelling further on the ultimate directions which have been issued by the High Court, it would be necessary to note at this stage that 3 reports were filed by the CBI after the remand of the proceedings. The impugned judgment of the High Court has dealt with the reports of the CBI. It would be necessary at this stage to make a brief reference to the report dated 5th February 2024, which is the final report which was filed before the High Court. The report of the CBI notes that the West Bengal School Service Commission had awarded a work order to a company by the name NISA Communications Private Limited for scanning and evaluation of the OMR sheets pertaining to the selection test for each of the 4 categories. The scanning of the OMR sheets was undertaken by the aforesaid company at the office of the SSC. It further emerged during the investigation that the company which was awarded the contract by the SSC had further assigned the work of scanning the original OMRs to an entity by the name of Data Scantech Solutions Noida, which was present at the premises of SSC for completing the scanning work. According to the CBI, after completing the scanning, the processed data in the form of scanned images of OMR was handed over by Data Scantech to NISA Communications in the digital form, leaving the original hard copies of the OMR sheets in the office of the SSC. According to the CBI report, the SSC handed over the answer keys for all subjects to NISA Communications Private Limited for evaluation of the OMR responses. CBI seized the server database of the SSC during the course of the investigation. On 15-16 September 22, 3 hard disks were recovered from the residence of a person by the name of Mr. Pankaj Bansal, a former employee of NISA Communications Private Limited at Ghaziabad. Certificates dated 19 September 22 under Section 65 capital B of the Evidence Act were obtained from Mr. Pankaj Bansal. During the course of the investigation, data files containing scanned OMRs, among other things, were seized from Data Scantech Solutions. The report of the CBI contains the following observations in para 12 and 13 of the report. Para 12, that a similar exercise of matching the data available on the hard disk of Pankaj Bansal with the data seized from the commission was done during the course of investigation, and it was found that there were mismatch between the two, inasmuch as the written marks awarded to candidates as available on the server of the commission had been increased to qualify undeserving candidates. This mismatch establishes that manipulation in marks of written examination in the case of many candidates was resorted to, and such candidates were identified. The comparison of these actual genuine OMR marks with the OMR marks available in West Bengal Service Commission server shows that there is a manipulation in 952 numbers of candidates of class 9 and 10, 907 numbers of candidates of 11, 12, 3481 numbers of Group C candidates, and 2823 of Group D. That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons and officials of NISA. These emails contained lists of candidates whose OMR marks were found to be increased in the server of the commission. Besides these, the emails have been exchanged between the staff of NISA themselves, containing the manipulated data of candidates. This shows the complicity of officials of Mrs. NISA in this conspiracy. The above noted investigation by the CBI indicates that it has found a manipulation in respect of 952 candidates for the selection process of assistant teachers for class 9 and 10. In the case of 907 candidates for class 11 and 12, 3481 candidates.
This will indicate that the marks were increased when they were uploaded in the server compared to the written examination.
That's right. So,
that's all. That clarification is just we wanted that.
yes. Apart from the above report of the CBI, the impugned judgments of the High Court contained in para 240 a reference to the fact that SCSC had submitted a statistical report of the 4 selection processes tabulating the alleged irregularities. The tabulation is reproduced below for convenience of reference. So, Lordship, see that with regard to assistant teacher, the irregularity percentage is 8.5. Assistant teacher 11-12 is 14%. It is larger in case of Group C and Group D. The High Court has also noted that in response to its queries, the SSC had submitted details of the recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. The figure submitted by the SSC indicated that the actual number of persons who were appointed by the board was in excess of the recommendations made by the SSC to the following extent. Assistant teachers 1539, assistant teachers 912 199, Group D 669 and Group C 416. On the basis of the data which was submitted before...
just 1 minute over here. The recommendation for Group D was that this is the enhanced number above that?
Yes.
It is enhanced number above the figure of, say, in the case of 11,610, 5596, 2037?
Yes, sir.
Yes, please. Continue.
The SSC had submitted details of recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. Figures submitted indicated that the actual number of persons who were aboard was in excess of the recommendations made by the SSC.
Oh.
So this is another fault, that some more people.
Yes, please.
On the basis of the data which was submitted before it by the SSC, the High Court has observed in para 241 that the illegalities admitted by the SSC cannot be said to be within tolerable margins in a selection process of a large magnitude, and that the SSC itself did not discount the fact that the possibility of the existence of further illegalities may still exist. The High Court further noted in para 273 that the SSC had not been in a position to state that it had checked all the records so as to be definitive about the number of illegalities, and the state government had also accepted that there were widespread illegalities in the selection process. On 19th May 2022, the government of Bengal in the school education department issued an order creating 6861 supernumerary posts of teachers and non-teaching staffs for absorbing the wait-listed candidates, and directed that appointment letters to such wait-listed candidates shall be issued in terms of the recommendation of SSC subject to the outcome of the pending litigation before the High Court. Now, this will be one of the issues which I am concerned with, which I'll elaborate later. During the course of the hearing, this court has been informed that the petitions under Article 226 of the Constitution, petitions have been instituted before the High Court to challenge the order of the supernumerary post to accommodate the wait-listed candidates. By an interim order, the government order creating the supernumerary posts have been stayed.
So what is your stand? You want the stay to be vacated or what?
No. We did not appoint. What the High Court has done in this case is that separately but independent of these illegalities, they have put a question mark to the state as to why these supernumerary posts were created. So with regard to that also, they have not issued a direction that the CBI inquiry should be done, how this order was passed and the entire.
Okay.
So with regard to that direction alone, which your lordships have stayed in this by disorder. I'm not saying we did not appoint anybody except one candidate which High Court had directed on humanitarian grounds. In this backdrop, the High Court by its impugned order has, while setting aside the appointments, directed that the OMR sheets available in the 3 hard disks must be uploaded on the website of the Selection Commission. Persons who had been appointed A from outside the panel, B after expiry of the panel, and C against the submission of blank OMR sheets must return all the remuneration and benefits received by them to the state exchequer together with interest at 12% per annum, failing which the outstandings would be recovered as arrears of land revenue. CBI shall interrogate all persons who had received appointments beyond the panel after the expiry of the panel and after submitting blank OMR sheets if necessary by undertaking custodial interrogation. CBI shall undertake a further investigation with regard to persons involved in the state government who had approved the creation of supernumerary posts to accommodate the illegal appointments, if necessary, by conducting custodial interrogation. And 5. The SSC shall undertake a fresh selection process as a consequence of the vacancies which are declared on the setting aside of the appointments. Other consequential directions have been issued. Primary submissions which have been urged during the course of hearing by counsel appearing on behalf of petitioners fall under 4 broad heads. 1. The data on the basis of which the High Court has set aside the appointments of nearly 25,000 persons, including assistant teachers and those appointed to non-teaching Group C and Group D posts is suspect. The foundation of the exercise is the certificates under Section 65 capital B issued by Pankaj Bansal, a former employee of NISA Communications Private Limited, from whose possession the 3 hard disks were seized. In a selection process having such a large magnitude, cancellation of the entirety of the select list would be a matter of the last recourse. Where a segregation of the tainted candidates is possible, only such appointments should be directed to be discontinued. 3. The above consideration must apply to A. fortiori in a situation where the petitions were filed nearly 3 years after the appointments were made. The directions to set aside the entirety of the appointments would have serious repercussions to employees who have served the state. 4. Where the appointments which are tainted are capable of being identified, it was manifestly unjust for the High Court to set aside the entire process. On the other hand, it has been urged on behalf of the respondents who have supported the judgment of the High Court that both the SSC and the state government were not in a position to state the possibility of further illegalities can be ruled out. When a systemic fraud has vitiated the entire process, the High Court was justified in setting aside the entirety of the selection process. The submissions which have been raised on behalf of the petitioners would merit further consideration. The certificates under Section 65 capital B of the Evidence Act were issued as the CBI report notes by Pankaj Bansal, who is a former employee of NISA Communications Private Limited. The legitimacy of the certificate which have been obtained from the above individual would prima facie go to the root of the data which forms the basis of the judgment of the High Court to set aside the entirety of the appointments. From the material which has been placed on the record before the High Court by the SSC and the CBI during the course of its investigation, a further issue which would merit closer analysis is as to whether appointments which suffer from taint can be specifically segregated. If such an exercise is possible, it would be unfair to set aside the entirety of
Main issue, in fact, let's be very clear, this is the main issue.
that is the main issue, Murad, except for the state which is concerned with that part.
That's the main issue.
Yes.
One issue is the material on the basis of which the finding is recorded.
But-
There's only one certificate.
But I must tell you, Lordship, Murad, that there is a group of petitions, Murad.
So are you supporting the
No,
proposition?
I'm not supporting it, but yes,
No, 1 minute.
the
If
state
the
is
state of
supporting
West Bengal supporting the proposition, it's not possible to segregate the taint from the...
No, the state is saying that supporting this segregation. Murad. We are saying that it can be, because CBI has not given several reports.
That's the
And
main
therefore-
issue. So that's the reason why I pointed it out. Please focus your arguments on that.
Yes. But there are a group of petitioners who are questioning the entire judgment. Based on
Maybe, they
65.
can be.
Yeah. The court cannot be unmindful of the impact of setting aside of a large complement of assistant teachers who have been recruited for both classes, which would be the consequence if the impugned judgment were to be upheld as it stands. Assuming that a segregation is possible, the court would have to determine the modalities which would be followed for that purpose. At this stage, the court must be guided by the fact that by its order dated so-and-so, this court had protected the appointments which had been made subject to the direction to the High Court to expeditiously dispose of writ petitions, bearing in mind the notice is issued. Then some interim protections were given, which you'll also find in para 34.
Yes.
In the meantime, the interim protection which was granted by this court by its order dated 9th November is continued, subject to the express stipulation that any person who is found to have been appointed illegally and is continued as a consequence of the present order shall undertake to refund the entire amount of salary which may be paid between the date of this order and the final judgment of this court.
Just one clarification. This interim order also inures to the benefit of those where the numbers mentioned.
Illegalities have been specifically found.
Yes.
Yes, that
16 and
covers
17.
them also. They are also continued. So, but with this stipulation that they will have to refund everything.
Cover 16, those covered by 16 in paragraph 16 and 17 is also, they're getting benefit of this interim order.
Yes. And they are in fact working also.
Yes, please.
Then the investigation by the CBI, which has been ordered by the High Court in clause 7 of its operation directions, will continue, but no coercive steps shall be taken. 36. This is well where the state is concerned. The High Court has, by its impugned order, directed the CBI to investigate the creation of supernumerary posts at all levels of the state government. This court, by its previous order, directed that no precipitate action would be taken in pursuance of the direction contained in clause 8 of the operative directions of the High Court, which is reproduced below. Which is this, Lord, that CBI will undertake further investigations with regard to the persons involved in the state government, approving creation of supernumerary posts to accommodate illegal appointments. If necessary, CBI will undertake custodial interrogation of such persons involved. Now, this expression to accommodate illegal appointments is incorrect. The order doesn't say that. It says it will to accommodate wait-listed candidates, because there were already reports of Justice Barr's committee, etc., pointing out illegalities. So the state was worried a lot about the vacuum which will be created. So they created supernumerary posts for appointment from the waitlisted, and that is also subject to the approval by the High Court. And in fact, no appointment has been made. So this blanket direction saying that you investigate everybody, right from the officers, right up to the cabinet, the posts have been created, so, and with custodial interrogation and all that. So our submission is that the division bench went too far ahead, which was unnecessary. Then para 37 stated that no appointment whatsoever has been made in pursuance of the order of the state government dated 19th May 2022.
You may therefore divide your arguments into two parts. One is with regard to segregation, and the other is with regard to the direction given in terms of paragraph 8.
So
you can divide your arguments into two parts. First, you deal with the segregation part, and then you can deal with the 8.
Now, as has been stated by your Lordship in this judgment order which I have read out, and which is not disputed, that one, there was Justice Barr's committee constituted to investigate the irregularities. Then brought the CBI investigation when the OMR sheets were recovered from NISA. Then they were handed over to the Selection Commission. They also submitted their report.
Okay. What we can do is, we can now go to the impugned judgment. Why did they say that it's not possible to segregate?
That's right.
May I add one aspect to that? I appear for the commission. But the commission has filed its written submission to the effect, my lord, that we support the segregation and that it is possible. Secondly, my lord, after this interim order was passed, we have carried out the exercise and we have filed an affidavit on 2nd of August of this year, my lord, indicating name-wise the persons who we believe are, my lord, capable of segregated, and my lord, the rest can be saved because there is 25,000.
That's in there, you know. Let's first see the reason.
Yes.
I only have page 255 of the impugned order. In fact, please have 252 minutes. Because one of the issues was whether these OMR sheets recovered from NISA's officials, etc., is reliable and should be proceeded, because that is the foundation.
No, one minute. We'll go to that later. You start this.
No, this is important. I'm not going into that issue.
It's very, I'll tell you the reason why I'm saying so.
Yes.
There's a misconception about 65B. 65B is only a mode of proof. The evidentiary value which is attached to a particular document, value is the weight which is attached to a particular document depends upon not the mode of proof alone, so they're connected, but to several other factors.
So I'm not going into.
Let's not go into that. So the second part when we deal with the second part, it will obviously answer the first part.
No, I'm not at all not going into that issue because I'm not questioning. State is not questioning all those of the monarchics.
There is a difference between the two. There's a huge difference between the two. Anybody issuing 65B certificate is only a mode of proof.
So what I'm trying.
It's not dealing with 65B doesn't deal with and say what evidentiary value is attached to that.
All that I'm trying is that in this paragraph 307, the law should just note it. I will not read it.
Okay, we'll come to that. Let's first read the reason. Therefore, I said
High Court, foundation of my submission is based on this. Namely, the High Court says that these are authentic, reliable, and everything. I'm proceeding on that point. I'm not questioning this.
okay, if you want to read, you can read that. If you want to, after having given that caveat, if you want to, please read
So
that.
just have the at page 253, last 5 lines. I'm not questioning this finding. For the sake. High Court says at the bottom of 252,
Start from 307.
yes, the certificate dated 16th September 2022 issued by Mr. Pankaj Bansal relates to the data contained in the 3 hard disks adherence to requirement of section 65B in the facts and circumstances of the present case has to be adjudged on the conduct of the parties to the proceeding. All the relevant parties have admitted the contents of the 3 hard disks and acted on it without any demur. The Selection Commission has acknowledged manipulation illegalities in the recommendations and withdrew cancelled the same. State has decided that the cabinet.
I take it that OMR sheets originals have not been recovered.
No,
They have been destroyed.
they were destroyed because
They have been destroyed. So original document is not available.
not available because petitions were filed after 2 years long gap, so they were not available. This is correct. Now all I'm saying is, and I'm relying on this, that once the High Court relies on the authenticity, valid.
This is the way there is a difference between the two. 65B certificate will only say that what is downloaded from the hard disk into the hard form is what is stated or loaded in that server or the hard disk.
Yes.
What was loaded on the server, whether it's through an authentic copy, is never given by 65B.
No,
That is never given by 65B.
no,
That's a question of evidence.
no,
There's a difference between the two. I'll give you one simple example. The call record details which we gave are downloaded from the server. That downloaded is first captured, then the calls are made, then there's a blockchain effect. Keep on changing. When a person gives that certificate, he gives a certificate that as I downloaded from the server, this is the data which is there. But he cannot vouch for whether there was any manipulation or change in data.
Sorry, before it was downloaded. That's what I was. I'm not questioning. Others will, learned council will address on that note. I'm not going into 65B. What I'm saying,
Please wait for your turn.
I'm making a very limited point here that High Court has in the last 3 lines, factum, validity, legality, sufficiency, authenticity of the data has been proved by the conduct and actions of the relevant 12 authorities subsequent to the seizure of the 3 hard disks and after CBI had shared such data with the relevant authorities. So, after recovering, then it was shared with the Commission, other authorities, and therefore, finally, the High Court feels that this authority, these data can be relied upon to adjudge whether there has been enhancement of marks in it or not. All those findings are based on the first prima facie finding that this is authentic and we can be proceeded with. This is all the limited thing which I wanted to point out. Now, kindly have a lot. Paragraph 312 at page 255. In the factual context of the present. Sorry.
thing we want to know. Is there any rule or prescription in the that when OMR sheets should be destroyed?
1 year.
Here is
1 year. We are asking a question. This is the way everybody's wanting to answer.
Exactly, brother.
Yes, please.
At page 255. The bottom para 312. In the factual context of the present proceedings, we have three options to explore, namely, dismiss the writ petitions on the ground of maintainability. 2. Explore the possibility of segregating the valid appointments from the illegal ones. 3. Set aside the selection made in the selection process in its entirety.
Now, as far as second option is concerned, we need not go through the judgment. We know the case law, so we can skip that.
Yes.
Segregation is the second option.
That's all right. The judgment cited
We know the legal position ratio. Why should we include them?
only the earlier judgments.
but we have given
Come to
Para 320. Para 320.
yes, please.
The authorities noted above have observed that cancellation of the selection process without appointment being given therein stands on a different footing than a selection process where appointments have been granted. In the second category, courts must shift the grain from the shaft if possible. In the event it is impossible or highly improbable to shift the grain from the shaft, then the court may venture to cancel the entire selection process. Prior to embarking upon such an exercise, it must be satisfied that the selection process was tainted on the basis of cogent materials. There must be sufficient materials gathered through a thorough investigation that there has been illegalities in the selection process. The appointees had benefited out of the illegalities and were a part of it, and that the appointments made were contrary to law. In respect of the four categories of the selection process involved, the written examination has been held. The written examination was in the form of OMR sheets. Original OMR sheets have been destroyed by SSC. Mirror image of the destroyed OMR sheets was required to have been preserved by SSC. CBI had seized the server of the SSC and did not find mirror image of such OMR sheets in the server of
This
SSC.
is factually correct.
Actually correct.
This is factually correct. Was mirror images of the OMR sheet preserved by the SEC?
Not reserved and not required.
1 minute. That's the second argument, but they were not preserved.
SSC is an authority within the meaning of Article 12 of the Constitution and have been enjoined with the task of undertaking the selection process. Last report of the CBI has stated that SSC appointed Messrs. NISA for the purpose of scanning and evaluation the OMR sheets. Mr. NISA had engaged another organization, Data Scantech, to do so. It is unclear as to whether the new agency had merely scanned the OMR sheets or was instrumental in evaluating the same also or not. Chairman of the SSC, in response to a query, the court has stated that he was not aware of the engagement of Data Scantech in the selection process, and that in fact he became aware of such name only from the court for the first time. No material has been disclosed as to who authorized Mrs. NISA to engage Data Scantech or that such instrumentality was lawfully engaged by SSC.
So, what is being held is this, actually, that SSC did not keep a mirror image with them of the OMR sheets. They had engaged NISA to undertake evaluation of the OMR sheets, and NISA in fact gave it to
Data Scantech.
Data Scantech. They also did not do it.
Yes.
The three discs which were recovered are from NISA or from Data Scantech?
NISA.
From Data Scantech.
NISA.
From NISA. NISA must have got that data from Data Scantech because they did it.
No, NISA took the data in its computer, then NISA must have given a copy
Correct,
to them.
correct.
So,
So 1 minute, please. So the data scanning or the OMR sheet scanning is done by Data Scantech, as per you,
as per the finding, yes.
as per the finding there, and that data was then, or the hard disk with regard to that was given to NISA because NISA is authorized by the SSC to undertake that. Yes, please.
Significantly, it is the claim of SSC that scanning of the OMR sheets had taken place at its office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely Data Scantech, who was not authorized at all. These raise questions as to the integrity, sanctity, and validity of the entire selection process, and giving to the root of the selection process, the evaluator of the selection process had been selected through a process which at best shrouded in mystery, if not downright illegal. then the conduct of the evaluator is the validity of the process of evaluation itself. Significantly, Mrs. Naisa had been appointed without an open tender. SSC had selected Mrs. Naisa ostensibly on the ground of its being the lowest tenderer from amongst the chosen few who were asked to participate. The parameters qualification required to participate remains undisclosed despite requests being made in court to SSC. No explanation has been provided to SSC in course of hearing as to how and why course of action had been undertaken in identifying the instrumentality who was to scan and evaluate the OMR sheets. Documents that have been made available on record does not suggest that competency, efficiency, and whether Mrs. Naisa has the requisite expertise to undertake such exercise was not considered by SSC at all. Letter of appointment of Mrs. Naisa contains only 2 lines which requires Mrs. Naisa to scan and evaluate the OMR sheets. No other terms and conditions of appointment have been specified. The appointment letter has been received by the one employee of Mrs. Naisa from the office of SSC. SSC had destroyed the original OMR sheets ostensibly by keeping a mirror image thereof in the server. CBI did not find those mirror images in the server of SSC.
Did the SSC at any time say that they had retained the mirror images?
No.
They never said that.
They never said that.
Under the rules, are they required to maintain?
No.
They are not. But isn't it obvious they should be maintaining that?
Because
1 minute, Mr. Vedi, that's the question. It should be asked. 1 minute. That's the question because you are also supporting that it's possible to decipher tainted from untainted. You see, the original paper is the OMR sheet. That's the fact. That's the primary evidence.
yes.
If any manipulation is done on the main evidence or main paper, it will be only visible in the OMR sheet. OMR sheets normally we have pencil marking, if I'm not mistaken, or pen marking.
Ball pen.
Now what happens is there are cases in which people don't fill up the full question paper, they don't give all answers, so they have possibility of putting those pen marks. You have to fill up the holes with blocks of holes, or that's a possibility which happens. There's also a possibility of changing the OMR sheet. I don't know whether each OMR sheet had a number. We don't even know that. Was it a number?
Not been a matter of inquiry.
1 minute, please. We don't even know how did the checking take place. So the name of the candidate was camouflaged, and the top portion was erased and given for when it was done for checking. Normally, checking is very simple. Just scan it to the computer, and they with your question. It's not very fast. It doesn't require AI, complete AI. It's not human driven. There's no human checking, except when you want to check. Sometimes what happens is who's marked 2. They can mark 2 also. Or sometimes you find it's difficult whether it's marked or not marked. Some hole, the marking by pen is there or not there. The issue would be because the originals are not available. So there is no way we can authenticate whether the original OMR sheets were identical to the scanned OMR sheets which are available on the server.
So the entire inquiry has.
But then how do you, if this is the position, then what is the fault in the finding of the High Court?
No, the submission is this, Lord, that High Court proceeds on the authenticity and legality and validity of the OMR sheets.
No, they do not. So
that's how.
No, Mr. Devedi, that's not. That's why I said there's a difference between 65B certificate. 65B certificate only says that the hard copies which are being downloaded or which are downloaded are the copies. Is the copy of the.
No, I'm not on 65. I'm not on 65B.
But it will not prove that what is scanned and stored in the hard disk is the original of the OMR sheet.
But that's how the High Court proceeds. High Court takes the OMR sheet and gives it to the SSC and to find out on the basis of comparison, because the marks obtained by the candidates selected and appointed are known. Now, based on the OMR, High Court finds not that the person who got 0 to the OMR sheet recovered has got higher marks. So that's how they say that marks have been interpolated for that candidate.
Okay,
so the basis of the
entire... They put that question, let's see what answer we get.
Yes. My respectful submission is that the
basis... Okay, let's read further from 325.
Yes.
The SSC destroyed the original OMR sheet.
OMR sheets ostensibly by keeping mirror image thereof in its server. CBI did not find those mirror images in the server of SSC. These facts have been effectively ruled out, an exercise of shifting the grains from the chaff. The non-cooperative stand of the SSC state and the board had added to the burden. The entire selection process is rooted in such mystery and in such layers that it is difficult to fathom the quantum of illegalities performed. That illegalities had vitiated the selection process of Mrs. Naisa stands established. We have discussed the illegalities so far discovered vitiating the selection process in course of our discussions herein, and will tabulate the same hereafter. The plausible inference from the materials made available on record and the conduct of the relevant parties is that the entire machinery was devised for the purpose of effectuating a hard to discover and even if discovered difficult to prove. Appointment of Messrs. Naisa, destruction of original OMR and non-availability of are some of the crucial points in the fraud that came to be perpetuated. Now this finding with great respect, so after 2 years and 3 years if the petitions are filed and the rule doesn't require beyond 1 year, so there is no requirement that it should be preserved beyond that point of time. And that is taken as a basic factor of holding its fraud. As noted above, in the course of hearing all these matters, SSC, state and board have perseveringly non-cooperated so that even the possibility of trying to separate the grains could be rendered nugatory. What has been produced by the selection process is not a cereal comprising of grains and chaff capable of segregation, but a product unfit for human consumption. Fraud perpetrated is deep and pervasive. Any attempt to shift the proverbial grain from the chaff would be an unprofitable exercise prolonging the agony and would put premium on dishonesty. Now, based on CBI the report, the whole thing is proceeding, and CBI has pointed out each and every candidate on what respects, on what grounds his appointment is vitiated. In the facts of the present case, blank OMR sheets have been submitted. Such candidates have been shown to have scored sufficiently higher numbers so as to be recommended for appointment.
This is factually correct, 29.
No, some people who have been appointed.
No, I'm not on that. Is it factually correct that there were some blank OMR sheets and these were shown to have, the candidates were shown to have secured higher marks?
This is not correct, but what has happened is that marks have been increased.
Marks have been increased by
But you got 0.
one. So OMR sheets on correction, on checking were found to have X marks, which was say 50, but the marks which are written
Marks are higher.
higher. But it is not that blank OMR sheet was
But even CBI doesn't report this.
Okay.
There's no basis for this. The exact nature of candidates fraudulently given the appointments cannot be identified, more so in the attitude of non-cooperation. There are other manipulation illegalities in the selection process which has come to light. Again, exact number of persons who have benefited out of such manipulation illegalities in the selection process cannot be identified in its entirety. Some have been identified. Identification of some is such that in respect of Group D, 48% has been found to be obtained by manipulation illegalities. The percentages of manipulated illegal appointments across the other 3 categories are on a reducing scale compared to Group D, but nonetheless sufficiently significant to question the validity of the entire process.
just pause it. Just be pausing here for a little minute. Now come to the order of 7/5/2024.
Yes.
The paper at page 13. Paragraph 13 and 14.
At page 11 was or the quoted paragraph 13.
Yes, we can go to the table itself.
From the
Sorry, not paragraph 13, 16 and 17.
Paragraph 16.
Yes. Or yes, we can paragraph 16 and 17.
On 15.
On comparison, just one minute. Paragraph 12, which is quoted there in italics, from the
On
CBI
a
report.
comparison of these actual genuine OMR marks with the OMR marks available in the Wbssc server shows that there is
1
manipulation.
minute now. What do you mean by this? On the comparison of the actual genuine OMR marks available
So he is referring to not to the OMR sheets recovered from NISA.
from data.
Yes.
Not NISA, not from data,
Yes.
but available with NISA.
Former employee of NISA who was at that relevant time an employee.
Okay, fine. Then the
That's
marks
the basis.
available on the WB.
The select list, the marks are contained. So they are trying to say that marks in some of the candidates are
About
manipulated
700,
and shown higher.
they were shown higher.
Yes. And how many are there? 9/5 of candidates of 9 and 10, 907 candidates of so 3481 of Group C, 2823 of Group D. So there's a complete identification by CBI.
we are aware of it. We are not.
That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons and officials of NISA. These emails contain lists of candidates whose OMR marks were found to be increased in the server of the commission. So the emails are there to corroborate that who are those candidates. Besides this, emails have been exchanged between staff and NISA themselves containing manipulated data of candidates. This shows complicity. The above investigation by the CBI indicates that it has found a manipulation in respect of 952 candidates for the selection process of assistant teachers for class 9 and 10. In the case of 907 candidates for class 11 and 12, 3481 candidates for group C and 2823 candidates for group D. Apart from the above report of CBI, the impugned judgment of the High Court contained in para 240 a reference to the fact that a submitted statistical report of the 4 selection processes tabulating the alleged irregularities. The tabulation is produced below for the convenience of reference. So, two authorities both have been, and they have made the basis.
That's one. The figures given in this table,
Yes, for
as per the
assistant teacher 9 and 10.
as per the SCC itself, where there were irregularities committed, are different from the table given by the CBI.
So CBI found more.
One minute. So the CBI says is where OMR sheets available, OMR marks available in the OMR vis-a-vis the marks which were available on the Wbssc server. The manipulation was in 95752 candidates,
Yes.
907 candidates, 3481 candidates,
Yes.
and 2823. And if you turn to the list which is given by the SSC, where they say that there were irregularities noticed in tabulation,
Yes.
there is a OMR issue in 808. I don't know what is the OMR issue.
OMR issue is where the OMR marks and the actual marks in the compact consults 3 discs are not tallied.
Okay. Then there is 771, 783 and 1741, whereas the details given in the CBI are much higher.
But there are small differences, they have reconciled it possible.
More
More or less same when coming. All the
no, that table doesn't tally. This one which are found by the CBI, they don't tally with the OMR issue. Then there's a rank jumping, and then there's alleged irregularity. What do you mean by alleged irregularity?
OMR class rank jump.
That's the sum total of the two?
Yes.
Okay. Fine. And then there is the case where additional or excess appointments have been made. Irrespective of the marks obtained.
Who are beyond the list.
Beyond.
So what I'm trying to respectfully submit, Lord, that the two authorities have been able to
Look,
identify.
now the factual situation as it is emerging is this. SCC did not maintain the mirror image. The original OMR sheets are not available. The only evidence with regard to the OMR sheets which are available is in form of scanned OMR sheets which was done by Beta and then given to NASA. There is evidence to show that the marking or the marks obtained as per the scanned image of the available data different from the marks which were entered in the server of the West Bengal Civil Services. There is also, as far as appointment of NASA is concerned, there are irregularities stated. The scanning itself, the process followed, there are irregularities stated. Because data did the scanning purportedly in the office of the SSC, but we don't even know whether the scanned images which were done by data, there are the actual scanned images which were recovered in the form of the hard disk. We don't even have that because 65B certificate will not say so and will not be able to be authenticated. 1 minute, please. Because then you have to lead evidence to also show that the hard disk which was recovered by the CBI were the actual hard disks which were installed in the machines or the scanners.
Yes, that is established.
That is going to be difficult. That's going to be very difficult for you to establish. Number two, the metadata in then those scanners will have to be examined to find out whether there was any change in those, because metadata will give you the date on which it was scanned and uploaded.
So CBI has done
1 minute. We know from the
Extensive.
CBI. We'll ask the CBI whether they have done that. We know
They
exactly.
have done
1
extensive.
minute. Now, please look at these are the issues which the High Court failed. If these are the facts on record, we cannot now segregate tainted from the untainted cases. Now, meet all these arguments which have been addressed in your own way, and other petitioners can also meet that argument in their own way. We now likely to hear you on that, and then on the second part with regard to the CBI.
So the record which is
Clarification we require. The details of all OMR sheets were found. Details of all OMR sheets of the candidates who had
appeared.
found in the server, or there was some missing.
There seems to be no finding that these three hard disks.
Everybody to inspect.
Please hear what I have to say, then you answer. There's no finding anywhere in the document that these three hard disks which were recovered all the candidates were they contained. Those three hard disks contain the entire data. There's no finding available anywhere.
That's to satisfy the court's
The CBI also doesn't say so.
That the Honorable Court directed
Pankaj Bansal, from whose custody these three disks are obtained, says all data, including the scanned images of what is saying so is not sufficient. Where is the comparison with your OMR evaluation marks data, which is at least available still with you? On that basis, do you say anywhere that entire data is available? You don't say so anywhere.
We're not saying. And one more thing which has been mentioned in the High Court judgment, that there was some blank OMR sheets.
Yes, fact.
Is that correct?
And
Were there some blank OMR
the
sheets?
report
also?
doesn't, CBI doesn't say that.
That is the affidavit of SSC itself, I show.
There is a line also.
So these are the issues you have to now meet those issues.
So with respect
Another
to
important,
Rather not issues, rather these are facts. Which
yes, yes.
another important aspect may I clarify, just for,
let them finish and we'll have it.
So, Lord, in greater detail, Lord, this aspect will be dealt with by the Commission, Lord, but I am, Lord, submitting, Lord, on a narrow footing, namely, that extensive inquiry had been done, one by Justice Bag's committee, Lord, which was appointed, the other, Lord, by the...
Tell me why did you create supernumerary reports? Why did you? What is the purpose of creating that?
Supernumerary post, Lord, because after Justice Bag's report was received,
When was that report received?
just in April 22.
The report was received. The report said there were irregularities.
Yes, they also found some irregularities, but not as extensive as the CBI report. It was on a narrower. Based on which, Lord, 269 appointments had been invalidated, which then came up in the interim stage to this court. Your Lordship stated the...
So they found there were irregularities committed.
Yes.
So in order to deal with that situation,
So, Lord, we...
instead of weeding out the persons who had been appointed illegally, you said, okay, create supernumerary posts.
For appointing the
No, but
wait list.
Mr. Devedi, tell me one thing.
Wait.
If you find irregularities committed, will you not come out first?
No, not for them,
But 1 minute.
for
But-
wait listing.
1 minute. The moment you create supernumerary posts, you are then ensuring that the persons who are tainted and wrong, who should not have been appointed, their appointment should continue.
No. The order specifically says for appointment from the wait listed candidate.
Correct? Well, the reason is this, that you don't want to throw out the tainted candidates.
No, Lord, that is not up to us because High Court says, Lord, they have to be non-ordinary. We can't retain them.
Okay.
We can't retain them. And we specifically said that this is subject to orders of the High Court. And we did not appoint anybody. Equally, more so, Lord, this order was challenged in some other petition which is still pending in the High Court, where an interim order is saying that order. And in these batch of writ.
you last on that. Let's hear the others. We'll hear you last on that for second one. We'll hear you on the line on that. We're not closing your right to be heard. We'll hear you in the line because the way speaking, that's the second part of the argument. The first part is.
So on this part, Lord,
I will hear you, but in the
yes, on the segregation aspect, Lord, I'm working on a narrow ground, Lord, namely that CBI was appointed to hold an extensive exercise, pursuant to which, Lord,
go ahead.
Quote one new is there. Quote one new. That is the first question. And this is the first one.
Thank you.
kindly look at two paragraphs, not 229 and 230 of the High Court judgment. The point which I'm making is that CBI has made an inquiry, looked into the OMR sheets, discrepancies, how many are beyond the select list. The Assistant Secretary of SSC has submitted a report in the form of an affidavit in response to the order dated 13th of January 2023, where the number of vacancies declared in Group D posts were tabulated. Number of candidates, I'm so sorry.
Go ahead. I've already
The
read
number
your
of candidates empaneled and the number of waitlisted candidates were also stated. Significantly, it has been stated that manipulated OMR sheets applied to SSC by CBI were 2819. Another affidavit in SSC has stated that NYASA was an agency appointed by SSC for the purpose of assessing scanning with regard to the 3rd Regional Levels Test 2016 for appointment of Group D staff. After receiving the OMR sheet and in compliance with the orders of the court, SSC had checked the OMR sheets and other data supplied by CBI in the form of hard disks. Whereupon it appeared that the marks of 2819 OMR sheets were lesser than the marks of the candidates as were kept in the server of the SSC. Out of 2823 candidates in which marks have been manipulated, enhanced 1911 candidates have been wrongly recommended. Then 231 similarly. So on each aspect, on a comparison, a specified number of candidates identified were pointed out, the number was pointed out, and that has been found in the tabulation. So both CBI and the SSC melodies, after getting the OMR sheets, have come out with figures, exact figures. And that's how at page 240 is the table which finds mention in the entry box.
Okay.
All that they say in 242 is that SSC did not discount the fact that possibilities of further illegalities exist. Now, nobody can discount that, but the point is that after extensive inquiry, if specified number of candidates identified have been mentioned, then why should we throw out 25,000 people against whom there is nothing? Keeping in mind that the petitions have been filed after 2 years and 3 years.
Number 306.
Yes. CBI in its reports have detailed how Mr. Pankaj Bansal, along with persons in the control and management of Messrs. NISA, kept the mirror images of OMR sheets and was providing data as called for from time to time by SFC. SSC, in fact, had responded to Right to Information Act applications providing OMR sheets to individual RTI applicants, claiming that such data was in its database. Affidavits filed by writ petitioners have borne out that such facts. SSC had provided Anindita Behra, writ petitioner, a copy of OMR sheet in January. Sorry?
You don't get interrupted. I've already read this paragraph. What is being pointed out in 306 is the SSC had taken the stand that they have the mirror images with them in the affidavits which were filed and when the OMR sheets were supplied. It says the affidavits filed with the 24 also. In January 24 also. That the database was stored in SSC database. Was supplied also from the SSC from its database. And again from its database. So if they were giving data, the OMR sheets from their database, where did their database of mirror image go? That's not how it. And you come to the, that's the one finding, and then you can come to page 305. This is the report, which quotes from the report. Let's read that part.
I can trace the whole of
these are your affidavits filed by the SSC, and the SSC in the response to the Right to Information Act said that OM sheets to individuals claiming that data was in its database. That's the finding recorded. The SSC had in the RTI application said that the OMR sheets copies are available in its database, and the affidavits filed with them again say that the OMR sheets are being given are from their database. There's now the stand taken by the SSC is they don't have any database of the OMR sheets.
So my learned friend will explain this further.
Okay, now come to page 245, 305.
Para 305. CBI has filed several reports in these proceedings. In its report dated 5th February 2024, filed in compliance with the order dated 24th January 2024, passed by us, it has stated as follows: that during investigation, it was revealed that the West Bengal Central School Service Commission, hereinafter referred to as Commission, had awarded a work order to Mrs. NISA Communication Private Limited for scanning and evaluation of OMR answer sheets pertaining to the selection tests of Group B, Group C, and teachers. Investigation has established that Shri Puneet Kumar was the then director and Niladri Prasad was then vice president of the said NISA during relevant period. It has been established during investigation that Shri Niladri Prasad was in charge of operations in respect of recruitment examinations conducted by the Selection Commission and frequently visited the office of the Commission to attend the actual operation part and did the requisite liaison on behalf of agency for necessary compliance of instructions given by Commission. Shri Puneet Kumar, being director, mainly looked after the financial affairs of the agency and represented it on record. Investigation established that scanning of OMR sheets was undertaken by said NISA at the Commission office at Acharya Sadan under direct supervision of Shri Niladri Das and in presence of the Commission officials. It has been further established that Mrs. NISA Communication Private Limited had further given work order with respect to scanning and the original OMR to Messrs. Data Scan Tech Solutions Noida, who remained present on the premises of the Commission for the scanning work. After completion of scanning, the processed data in the form of scanned image of OMR, scanned data, etc. were handed over by Data Scan Tech Solutions to NISA, who took the same to their offices located at Noida in digital form, leaving the original hard copies of OMR sheets in the office of the Commission, handed over the answering keys in respect of all subjects to NISA for evaluation. That by scanning.
Just one. Yes.
So then the next two paragraphs they are just describing how they proceeded to recover the data. That by scanning the original OMR sheets by Messrs. Data Scan Tech Solutions on behalf of NISA, files were generated containing scan number so-and-so. That a sample of the DAT file generated during scanning of the OMR sheet is cited as an example below. Responses of candidates in the OMR is appearing as response code in alphabets while it indicates in the OMR sheet that 2 such DAT files were generated since scanning is done twice to avoid technical error. Thereafter, a final DAT file is prepared which is called a clean data file. After receiving the answer keys from the commission, the same is compared with the final data and a DBF file is generated having the score of the candidates. That during investigation, server database of the commission was seized by the Central Bureau of Investigation containing all the data pertaining to selection tests of Group D, Group C and assistant teachers. That during investigation of the case, 3 hard disks were recovered on 15th and 16th September 22 from the resident Pankaj Bansal, ex-employee of so. The certificates of Shri Pankaj Bansal were obtained in triplicate with regard to genuineness of the data contained. That during investigation, data files contained scanned OMR sheets, DAT files, etc. pertaining to aforesaid commission recruitment matters were also seized from Data Scantech. During investigation, the hash values of the data files of Scantech were matched with the hash value of corresponding files recovered from the hard disk seized from Pankaj Bansal and was found to be matching, which establishes that the data contained in the 3 hard disks recovered from persons were not contaminated. This is important. That a similar exercise of matching the data available on the hard disk of Pankaj Bansal with the data seized from the commission was done during the course of investigation, and it was found that there were mismatch between the two inasmuch as the written marks awarded to candidates as available on the server of the commission had been increased to qualify undeserving candidates. This mismatch establishes that manipulation in marks of written examination in the case of many candidates was resorted to and such candidates were identified. The comparison of these actual genuine OMR marks with the OMR marks available in the server shows that there is manipulation in 952 numbers of candidates, 907 and these figures the Lordships have seen. That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons and officials of NISA. These emails contained list of candidates whose OMR marks were found to be increased in the server of the commission. Besides, this email have been exchanged between the staff of NISA themselves containing manipulated data of candidates. This shows complicity of officials of NISA in this conspiracy. That during investigation, it emerged that during 2019, Shri Niladri Prasad left NISA and started his own business in name and style of ND Info Systems, Noida, and was engaged in the business of data processing in line of Mrs. NISA. The said Niladri Prasad poached Pankaj Bansal, Kuldeep Singh, Anoy Saha, Muzammil Hussain and others support staff from NISA. It has emerged from investigation that before leaving NISA, Niladri Prasad and his staff retained all the data pertaining to recruitment examinations, including data group C, so-and-so and teachers, with them. Even after leaving NISA, Niladri Prasad, Pankaj Bansal and Muzammil Hussain kept providing assistance to commission in matters of RTI on the basis of data of NISA, which was manipulated and also hosted in the commission server. This also establishes that As Bansal and Hussain who were involved in entire scam, it was in their the data has been manipulated and therefore they continue to extend assistance solely to avoid detection. That if there would have been no manipulation, the scanned images of OMRs available with Commission were sufficient to respond to RTI queries. Investigation revealed that Commission has destroyed the original MR sheets and the scanned images of original MR sheets in the year 2019.
One minute, this is important. It says the Commission destroyed the original images, the original MRs and scanned images of OMR sheets in the year 2019. So the Commission had made scanned images of the OMR sheets.
Yes.
But there is no requirement to be retained for all time.
That's something separate. I'm not on that. We are not on that. But there were scanned images of the OMR sheets which they had retained.
Just the original OMR sheets and both were there according to this report.
Leads to an inference that...
Which again leads to an inference that the same were destroyed to keep the matter under wraps. That investigation establishes that as a reward for doing aforesaid manipulation in the OMR score, Messrs. NDISPL of Niladri was provided work for recruitment of teachers in upper primary conducted by Commission. Apart from this, many other recruitment works are also assigned to Niladri Das by the Government of Bengal. Various lists of candidates related to upper primary were communicated to Niladri Das and Sinha. Sharmila Mitra were found in the email of Niladri Das, which shows his criminal conduct. The result of comparison of these records collected from data Scantech with that of hard disk seized from Pankaj Bansal. A. As discussed in the preceding paragraphs, the hard disk recovered contains the marks of written examination, typing tests, etc. This marks, when compared with marks available in Commission server, resulted in the identification of candidates whose marks of written examination typing tests were manipulated. Messrs. Data Scantex made the initial scanned images. These scanned images were given to NISA. Pankaj Bansal retained a copy of the scanned images. That in connection with candidates of class 9 and 10, 11, 12, scanned images of OMR sheets as collected from Data Scantex solutions pertaining to the alleged candidates whose OMR sheets were found manipulated were matched with the scanned images.
Now, this also shares that there was OMR marks were found manipulated were matched with the scanned images available on the hard disk, and the same were found to be identical.
Yes.
So, 1 minute. What do you mean by this? The contention of the candidate so and so, the scanned images was as collected from so and so pertain to alleged candidates whose OMR sheets were found manipulated were matched with the scanned images of.
So Data Scantex and the hard disk of Bansal,
Okay.
both are matching.
The response string of the candidates.
The response string of candidates pertaining to 9, 10, 11, 12 as recovered from Data Scantex matches with the response string available in the hard disk seized from Pankaj Bansal. On the basis of these response strings, the actual genuine OMR marks of 9, 10 were determined. The comparison of these actual genuine marks with the OMR available in the commission server shows that there is manipulation in 952 numbers of candidates of 9, 10 and 907 candidates of so. The response string of candidates pertaining to Group C, Group T as recovered from Messrs. Data Scantex Solutions matches with the response string available in the hard disk seized from Pankaj Bansal. On the basis of these responses strings, the actual genuine OMR marks of Group C and Group D.
For the corrected answer. The suggested corrected answer. That's the response string.
The marks as they
Is that
exist.
correct? Or did it stand for something else?
What is it? Absolutely not. So the answers which are there in the scan and these are both matching.
Okay.
The key answer.
The key answer, the correct key answer is the response string. If the response string is the key answer, correct key answer.
That's the usual answer. Response thing, I may not be 100% correct. I asked my briefing counsel yesterday, we are private candidates. When you answer, they put a line like this to your dots in the OMR sheets. For example, AB.
Okay, they put that line so that nobody can change it.
That response string is then fed into some evaluation software. And that is what a response string as explained to me.
No, but the response string is not put by the candidate or is put by the.
Not by candidate. That is not by candidate, it is done as some basis of evaluation.
Let's say evaluation, that's a computer AI generated.
What they have explained to me.
Okay.
I asked them the same question. What is the response? And that other thing which was matched, that data frequency, they explained to me that every file which we read has a particular frequency. And so, hash value. That every file has a particular hash value.
Not the frequency.
So, hash value. So that somehow anyway, I'll try to put it together with my turn.
Yes. Yes, please.
Then that by investigation established that the genuineness of data of hard disk seized from Pankaj Bansal, that in compliance with the solemn order dated so-and-so, this 3 hard disks in original seized from the residence of Pankaj Bansal along with certificate under Section 65B of Indian Evidence Act obtained from Pankaj Bansal are being submitted before this court. The 3 hard disks are in sealed condition. The certificate of so-and-so in original is obtained. The Honorable Division Bench at High Court directed CBI on 24/1 for production of the above mentioned 3 original hard disks seized from Bansal, and in compliance with the direction, all the 3 hard disks were returned back by PFSL Hyderabad in sealed condition and are now being produced with this report. That the present status of all the above mentioned 4 recruitment cases is disposed of from investigation.
Okay, enough. That's all.
Therefore, that's what I'm trying to submit based on the CBI report is
Yeah, but anybody else? Who else would like to start?
that other point I'm reserving, in case.
But I appear to the commission that we are here to assist. Everybody who was found involved in the scam have been proceeded against. They are not serving jail time somewhere. So there is a completely new organization before your lordship, and we are here only to assist. We are concerned that 25,000 people may lose their jobs, where some people were admittedly involved in wrongdoing, but not everybody was. So, my lord, we filed affidavits before the court saying that it is possible to find out which are the tainted candidates. We also said so before this honorable court. And now, my lord, the CBI also takes the same stand. There are 3 or 4 aspects on which, my lord, it has been found that there may have been wrongdoing. My lord, we had certain data with us to start with, and my lord, that has been subsequently again reconciled. There is a little difference here and there, but ultimately, my lord, we have been able to reconcile most of the data. Now, the fact is that the OMR sheets were, my lord, there are 26 lakh candidates in each batch of these examinations. And my lord, these examinations are held from time to time. So, my lord, it is not possible to store that volume of, my lord, OMR sheets. The rules provide that they are to be destroyed mandatorily, precises, then they can be preserved. But in this case, no dispute arose till 2021. This is, my lord, the batch of 2016, advertisement of 2016. And, my lord, the process was completed and the persons concerned took office, my lord, in 2019. The writ petitions came to be filed in 2021. And the panel had also expired by that time. It had been extended briefly, but it had expired by then. Now, my lord, your lordship is seeing, therefore, the original OMR sheets are not there. However, 2 sets of data are available. One is NISA scanned and my lord, prepared the mirror images of the OMR sheets. That was the job given, that's the first part of the job given to NISA. My lord, no job was given to data scan. The fact that NISA was using people from an organization called Data Scan to sit in the office of SSC and do the actual job, my lord, was not brought to the attention of the SSC at any stage, is what we have stated. So, my lord, as far as we are concerned, everybody we dealt with was NISA, was either a person employed by NISA or authorized by NISA, my lord, but they were all NISA. Now, NISA had mirror images. So, my lord, in the initial stages, when people made RTI inquiries, we obtained those mirror images and gave answers. But, my lord, subsequently, when my lord, it became clear that this should be kept separately, my lord, we did not give any such answers thereafter. It is not an affidavit of the commission. That's not an affidavit of, my lord, the commission. The commission has filed, my lord, 3 affidavits, 4 affidavits, the dates of which I'll give you, your lordship, my lord. 24th is not.
An affidavit, your communication to that.
That's right, my lord. So therefore, my lord.
That you said that it is from your database.
So therefore, my lord, the database of NISA was also taken into consideration.
Your database.
Yes. Because, my lord, they were authorized to do this job, my lord, on our behalf. So then, my lord, when the discrepancies arose, my lord, CBI took custody of, my lord, our server, which does not contain, my lord, any mirror images.
Five to 27 lakh candidates in each category.
22 lakhs candidates. My lord, I think 22, my lord. May not be 26, but there were 22 lakh candidates.
In each or all together?
There are 4, my lord, posts here. There are 4 categories of posts. One is, my lord, up to 10, then 11, 12. Those 2 are, my lord, teaching posts. And then, my lord, there is Group C and Group D, which are, my lord, non-teaching posts.
So we wanted to know whether there were 27 or 22 lakh candidates in each category or...
No. All together, my lord. What this batch, this entire batch, my lord, we are dealing with
22 lakh.
At 22 lakhs, my lord, examinees. Approximately, my lord, there would be. We can give exact figures also. The figures are maintained.
And the names of the candidates were erased or what?
No. Nothing is erased.
No. In the OMR sheet, the name of the candidate.
In the OMR sheets maintained by NISA is a scanned image.
That scanned image, the name of the candidate is mentioned?
No, because, my lord, that is, my lord, the answer sheet. They would not write the name of the candidate on the answer sheet.
There will be roll number?
There will be roll number, my lord, and my lord,
There will be roll number mentioned there?
Barcode, yes. Roll number, barcode, all that is mentioned.
Barcode or roll number?
My lord, I think, my lord, roll number definitely is there. There may be a barcode. Codes.
A QR code.
Yes, QR.
OMR sheet with the names and signatures are there.
Everything.
And roll number.
My lord,
OMR sheets are there?
yes, yes.
Blank with the public. They were given in court, not for inspection. Nobody came.
And not only public, we need to
My lord, page 246 of the judgment gives an idea, my lord, because there, my lord, the CBI, my lord, has given the report, my lord. Page 3, para 305 to 45, your lordship has seen, my lord.
They have seen that. Yes.
Barcode, roll number, venue code, booklet, and my lord, just before that,
340.
246, if your lordship sees, my lord. Para 6,
The scan number, barcode, roll number, venue code, booklet serial number, subject code, category, gender, medium,
gender,
code.
medium. And will please see the paragraph immediately preceding that while scanning the original OMR sheets by Data Scan Tech Solutions on behalf of NISA, 2 .dat figures files were generated containing scan number, barcode, etc.
Yes, please.
No, that is before. One. Para 289, my lord.
But normally, tell me one thing.
Yes, sir.
When you scan a data, then shouldn't you be maintaining the scan data yourself before you give a copy to the other side for the checkers to verify that? You normally what you will do is keep a data with yourself, because once you scan, then the marking is done immediately. There's hardly any time gap between marking and scanning.
Well, at the page 236.
The marking and scanning was done simultaneously.
Yes, by NISA itself.
So then you should have retained everything with yourself.
Lord, we are.
No, please. It's very simple.
Yes.
Marking and scanning is done simultaneously.
Yes.
So then you retain the data with yourself.
Lord, we retained, Lord. What we retained is the server is
No. What you did not retain, what has been found is with NASA and data.
Not data scan. Data scan does not come into the picture.
No,
It has
no.
come from NISA.
NISA separated himself. But data. When the scanning was done, that data, the person of the person who confessed was an employee of NASA.
Yes.
But he was he working with or he had started data?
Well, these facts, well, we are not able to verify. CBI has found that at some stage he was working for data scan, but Millard.
SSC doesn't know anything.
Please,
All right,
let us put it very clearly.
Let me place, Millard.
Just
Para 33.
In case scanning and marking was done simultaneously,
Yes.
then you should have retained that data with you.
Yes.
After all, it's
As I said, Millard, I can only assist whatever your lordship decide. Millard,
you
I
are
can only
making the
assist.
time very clear. You are not happy to take any particular position. You say you want.
No. My position, Millard, is
Yes,
that,
it's possible to.
that it is possible to segregate
But
because there are two.
look, the question today is not only that. The question today is authenticity.
Yeah. Now
Of
that
the-
authenticity.
Authenticity
Yes.
of the data as found or the scanned images as found in the 3 hard disks.
Yes.
That itself is a subject matter.
Yes, Millard. My learned friends are saying that you cannot rely upon that data, Millard. That is true. In that case, Millard, we are only left with the server.
option is what the High Court did.
No, Millard. Then the only option is to go by the server, which is maintained by the SSC.
No, but your server is zero.
No, server has all the final data, Millard.
No.
Roll number and mark.
No, that is manipulated. All manipulated.
You know,
That's all
manipulated. If we look at Millard, what Pankaj Bansal has provided.
Look, there is certainly manipulation done at your side. Whether any manipulation was done at Pankaj Bansal's side is still unknown. If we go by the prosecution case, as per the CBI, Pankaj Bansal will probably, in case there is no manipulation done, nobody will be able to, on the basis of evidence, do anything. If your employees are concerned, they will be in a problem. Because there is a difference between the data. What has been highlighted is the difference between the data maintained in the servers and what is uploaded in your mark sheet, which is uploaded.
No, Millard. The server is ours. The server is SSC server, and Millard, the 3 hard disks are the hard disks which
Of Bansal.
which have been taken from.
But there is a mismatch between the data in the hard disk
Yes.
and the data over here.
There is a mismatch. Correct. So, Millard, it is my.
Okay, anybody else?
Millard, now, Millard, just 2 more things. Millard, we have now done the reconciliation. I need to just point that out to your lordship, Millard. Kindly see, Millard, 2 things. One is our written submission, which is part of volume 6. It's a short written submission. Volume 6, Millard,
When did the new management come?
2022. Millard, there is a so-called convenience compilation, Millard.
Given digitally.
It's given digitally.
Pen drive में दिया है कल. उसका बोलो. Page 14.
14.
Page 14 of the volume 6 of the convenience compilation is a short note that we have filed to carry out the segregation. If your lordship is satisfied that it is possible, then my lord.
No, the difficulty today is we can't even vouch for the authenticity of the OMR data. Though there the hash values have not.
Nobody is saying.
Though the hash values over there have not undergone change. If one looks at the data which is available.
Yes.
Who's appearing? Anybody appearing for the CBI?
Yes, Lord. CBI is also here.
Tell me one thing. Were you able to ascertain the date on which the OMR data was captured? What's the date? Metadata says which date? Can you take it up and let us know by 2 o'clock? What was the date on that?
But it should have been not the original date itself. When they scanned sitting in the officer assistant.
On that, we would like to have that.
And also whether you have the full data of those 20 and odd lakh.
22 lakhs candidates.
All the data. No, it doesn't say so in favor. Just check with them whether it does.
That whether the hash values indicate the date on which the data was captured and whether there was any change in the data thereafter.
So, my lord, please come to my lord. We have given the judgments. I don't have to trouble your lordship with that just now. Paragraph 3 are the judgments, my lord.
We don't have to go through the judgments.
Yes. Your lordship doesn't, my lord. I just wanted to add one, which is the most recent judgment, my lord.
The ratio is not, the judgments are not required. Sir. The ratio is well established.
Yes.
So we are proceeding on that ratio. Legal proceeding.
True, my lord. Your lordship is proceeding on that basis. Just for completeness, my lord, the last of the judgments is 2024, volume 9 SCC, 763. 2024, 9 SCC, 763, 743, para 62. This is Vanishka Yadav. That is in addition to what is given in para 3.
Okay, fine.
Now, my lord, kindly see the manner in which, my lord, or what is the result of our exercise from paragraph 6 onwards. Commission prima facie noticed, first of all, my lord, even before CBI comes into the picture, Commission prima facie noticed that there were candidates who can be said to have appeared to have jumped their ranks. That is to say, people having lower rank have been preferred over persons having a higher rank. It was also prima facie seen that some candidates have been recommended and appointed without being in the panel or appointed without recommendation. Then, my lord, as far as assistant teachers 9-10 are concerned, 74 are rank jumped and out of panel 111, etc. We came to the conclusion that there are irregularities in respect of 1,200. Then, my lord, para 7 talks about, my lord, the figures which have come from the CBI investigation. Even in the investigation by the CBI, it has been found that some appointments were alleged to be manipulated by manipulating the OMR scores. So, my lord, this table will give your lordship, my lord, the correct figure why it is 808 and 772 and not 952 and 907. My lord, the CBI found that there was a mismatch of OMI score as between, my lord, the hard disk and our server. 952, 907, 2823. But, my lord, out of that 952, the only 808 was in fact appointed. My lord, we don't have to, my lord, take into account those who have not been appointed. The figures, if we take those who are appointed, my lord, are correctly reflected as 808, 772, 782 and 1911. Then, my lord, the CBI has also, my lord, relied on the same data. And only one more thing I need to point out, my lord. That on 2nd of August, we filed, my lord, an interim application giving, my lord, the complete details of the persons concerned with names. That is, my lord, IA 171058 of 2024, dated 2nd of August 2024. And in this, my lord,
Yes, please.
my lord, in that, my lord, your lordship will find that each of these 4 categories, my lord, under each category, my lord, we have given names in the annexures as to what is the nature of the my lord, irregularity which has been
Okay.
as far as
That's all?
yes,
Okay. Yes.
my lord, that 24th January is not
I
a
thought you are paying for the board?
no. SSC, my lord, is the commission. We are, my lord, the examining body, the recommending authority. Results are given out.
But
And, my lord,
then it's very strange. One thing is very strange, that people who are not even recommended or who are not qualified, how did that happen? They were issued letters.
my lord, those are the irregularities, my lord, which have been documented.
No, I know, but that's very strange also. I can understand manipulation in the results and that leading to, letters of appointment.
My lord, we are not
But
here,
in
my lord.
this case, it's more than that, even when they were not.
My lord, we are not here to defend that. My lord, they are in custody. The persons who are involved are in custody.
Goes up to the education
We are not here to defend that. We are trying to see, my lord, whether we can save.
It's a very, very serious thing.
Of course, it's a serious thing, my lord. They are in custody. My lord, my learned friend is just telling me, my lord, that 24th of January is not our affidavit. That your lordship.
Letter.
It is a letter given in response to an RTI.
Correct.
And there, my lord, we were relying on the data which was lying with NISA.
It's in our data.
Sorry.
In your database.
My lord, because, my lord,
You are now identifying with Pankaj Pant.
no, my lord, we are not identifying. But, my lord, they were the people who were doing this particular part of the job. No.
That's
My lord,
incorrect.
it's very, very. If it is
Understand, can be it's incorrect information.
My lord, no, my lord, kindly let me just make one my lord, statement to your lordship. Every individual case that your lordship wishes to go into, my lord, I will give an answer. Because there are several situations where, my lord, something is given and then later on it is re-asked for, it's re-given.
The difficulty is this.
Yeah.
What is weighed in the High Court, we are not saying one way or the other. What is weighed in the High Court is, it cannot even authenticate the original database, whether it's reflective of the true OMR sheets. And there are indications and factors into account which create doubt about the original database.
So, my lord, correctly. My lord, but the High Court, my lord,
Whether it's right or wrong, that's something for us.
but my lord, the High Court does in fact accept the CBI report.
No, it doesn't. It uses that as a basis. CBI report is limited to the effect that there is a mismatch between the appointments and the database.
No, my lord, numbers also.
If mismatch means all that.
Yes. So, my lord,
But
CBI also is proceeding against.
CBI has not been able to ascertain and go into the question because there, in criminal matters, the benefit of doubt is available. Proof beyond reasonable doubt is available.
Lord, all that will come later.
Civil matters, here we supply the principle of probability, which is very different.
However, my lord, at the end of that exercise, my lord, what I am submitting is, at the end of that exercise, there will still be a large number of persons, my lord, around 25,000.
Only question which you have to answer,
Yes.
if we get the answer,
Yes.
that the database which was available
Yes.
is the actual authentic database of the OMR sheets or not, we'll be able to ascertain.
My lord, that the CBI says it is the authentic database. My
Cannot.
lord, your lordship will.
They have not been able to ascertain that. They have left it blank. They have left it neutral.
That's the basis of saying, my lord, actual.
They have left it neutral.
Well,
Because and that's the role of an investigating agency.
Yes.
Because when they're not able to ascertain it, because they could have only ascertained it on the basis of original OMR sheets. There they have not been. But I'm still worried about blank OMR sheets question, whether that's correct or not. Whether if you have a blank OMR
My lord, it is not enough to.
then the possibility of change of OMR sheets.
No, my lord, there is no such case. My lord, let me just indicate one thing, my lord. Suppose there are blank OMR sheets, my lord, in the scanned copies. My lord, what is the marks which have been given to them?
No. Then when we know from the other side.
Yes.
Yes.
It's not enough to say there is a blank sheet. It must be shown that blank sheet led to somebody getting 100 marks and will not getting appointed.
Yes.
The mail address after the board.
Please, Milord. I have here the board with my learned friend Mr. Sanjay Ghosh, Milord. So this is a Mahabharata which required 2 Sanjay and I see a third.
No, that's not the case.
Please, Milord. Well, your Lordships is grappling with the question of whether things can be desegregated, whether it is absolutely necessary to throw out everything, or is the data in such a shape that it would support the CBI case? Because ultimately, my lords, if your lordships were not to accept the data, then it would also probably impact the CBI case. So we have
Please.
We have to proceed on the basis.
One minute. I think you are basing your case slightly differently.
Please, Milord.
Everybody who's argued till now says accept the CBI data, but on the basis of the CBI data, don't throw everybody out. Segregate and apply the CBI data and segregate. That's the truth.
That's the thing.
Are you making a different case?
I'm also saying the same thing.
That's the way everybody's arguing.
Please, Milord. Please, Milord. And like based on the CBI's own written submissions, my lords, I thought we should do a reverse exercise.
Look,
How much
as I
is
said,
untainted?
1 minute, please. To say again, the civil matter is slightly different from the criminal matter.
I take it, my lords, and
And the standard of proof, the principles of proof are intact. So the findings recorded by the High Court proceed on the CBI findings, but they go beyond that.
Please, I take it. And my lords, I have a limited role in as much as I made almost all the appointments based on recommendations from the commission. There are a few cases which are not on recommendations. That's the allegation. That's a separate thing. My concern, more than the jobs, is to have continual education in the state of West Bengal.
No, you can't. I'm sorry, Mr. Hegde, we will not permit that argument to be made for the simple reason, in case we accept the judgment or we accept your proposition that it is possible to segregate. The third argument that this education is to be provided and therefore ignore that.
I'm not asking your lordships to bless everything. Let me put it that way. I'm not asking for a
Don't
total absolute.
that
I just want to bring the consequences. And my lords, first let's see what is the nature of the problem. If your lordship can kindly take the charge which I handed over.
It's finding.
This is as per the CBI's own data, my lords. Now I've segregated it according to the posts. Now, as far as the assistant teachers from the 9th and 10th standards are concerned, the CBI data when totaled up comes to 979 out of 13,056 vacancies. So the untainted in the 9th and the 10th is 92.
This includes the additional ones also appointed?
Please, my lords, everything.
This includes the additional ones who are appointed or without the additional ones?
All based on this. No. So therefore, my lords, the figure of untainted appointments is 92% in the 9th and 10th. As far as the assistant teachers for the 11th and 12th are concerned, untainted is again just 5% less, 87 in 0.31%. So there are 730 vacancies. The real problem arises in Group C and Group D. And there, my lords, the untainted as far as Group C is concerned is 52 and Group D is 49. They are all identified, my lords, and it is to that extent it is severable. My lords, I take your lordship's caution about the consequences, but may I venture to state, my lords, that recruitment of teachers, there's almost no state where there haven't been problems. There haven't. I've appeared in cases from Uttar Pradesh, and I don't want to perpetuate. I come from a family of teachers. I understand the problems of having bad teachers. But here, where the majority is 92% and 87% who are untainted, who have got a job. At this stage, my lords, to undo everything, that may be a bit harsh, my lords. So therefore, where a segregation exercise is demonstrably possible, then please, my lords, Mr. Ghosh is right. So the last recruitments are 2016. We are in 2024, and if we were to restart the commission and everybody were to restart the exercise after this, there would be we also have the attrition factor of retirements, resignations, and all that. So, please, my lords.
Okay, that's all. Yes, please.
Please, my lords. Yes, and then that was one administrative thing also, my lords. The academic year for this year, February exams start, board exams, so it's after May or something. Then the process for the year.
You please tell us you're appearing for class C and D or teachers.
My lords,
No, others. You are appearing for everyone.
I beg to appear for the petitioner in item 1.2.
No, you are C, D, which class are you?
Group 9 and 10 and Group C.
Group C.
Group C, one candidate.
52.77%.
I am appealing for some.
No, what happens? This half is gone.
Let me start with.
I don't know whether दाल में काला है या सब कुछ ही काला.
My lords have very prettily put the issue. The important issue is in regard to the very authenticity of the documents which have been relied on. This Honorable Court on 9th November passed an order which required the authenticity of the documents to be seen. 9th November 2023. The matter goes back to the division bench, and at page 900 of the compilation on 19 January proceedings, the division bench notes that this is the issue which has to be gone in. The CBI sends the documents for verification to CFSL. CFSL sends a report that they are not able to look into the authenticity of the documents because they are too bulky. This is noted in the proceedings of 24 January 2024. On 5th February, an affidavit is filed by CBI under section 65B and a status report is also filed in regard to documents which have been seized on September 16, 2022. This certificate had not seen the light of day from September 16, 2022 till 5th February 2024. In spite of several days of arguments in this Honorable Court where Mr. Patwaria had appeared and the matter, at no stage any of these had been produced. Now, the division bench of the High Court says Article 12 authorities have accepted the authenticity of these data furnished by CBI and they are not questioning it. These affected candidates were never given an opportunity to see even these documents. One day some...
No, this is wrong.
That's incorrect.
Look, we will not go into this way of line of reasoning for the simple reason. In a writ petition, you need not, in a case of this nature, need not impede all the successful candidates. It will become impossible, unwilling. Everybody knows about the litigation. If they want to come forward, they can come forward. We will not permit that. We will not go into that. There has to be some class section litigation where we will apply order 1, rule 8 and proceed accordingly. There are going to be some limitations on that, on applying the principles attached to this like that. Anyway, we are hearing this.
These affected candidates should be given some opportunity at some stage. Please see, when this Honorable Court specifically directed this to be gone into how the High Court has approached.
This will be very difficult if we accept that. Otherwise, we'll have to make all 22 lakh candidates.
No, but not 22 lakh candidates. It is only in respect of the appointed candidate. Selected and appointed. No, but our appointment cannot be set aside.
Our Babu is sector, take all that into account. They say either review or revision. That's the right way.
No, today the situation is there is a
Please
prosecutor.
argue on the merits. Please argue on the merits. We're not rolling this. We're rolling the wheel back.
My respectful submission is there is no finding by any authority, independent authority, in regard to the authenticity of the document. It is because persons who, according to the petitioners, have been involved.
The facts on record are very clear. That's why we went very slowly when it came to the facts. The SSC, there's some affidavits saying that we have the record, but they now say that they did not keep them available. 1. OMR sheet, physical forms, not available. OMR sheets were scanned and also checked and evaluated in the office of the SEC. But they did not keep a hard disk with them. Their hard disks are found with two other places. They are matching. How did the two develop? Whether they were done simultaneously, what happened, we don't know. CBI will get. There is also indication that the marks available on the, as per the OMR sheets on the hard disk, and the maps available and allotted to the candidates as per the data available with West Bengal's commission are different. Now it raises another question: whether there were another OMR sheets which were clearly reflecting the same marks as the OMR sheets, as the 65B certificate, it serves no purpose. When you put a 65B certificate, it only says this is the hard disk. That's all.
Or taken away by an employee to his private residence.
That's all.
And not recovered from the place where it should have been.
Not even recovered from the company which was given the task. So that's all the more serious.
Then in which case
it takes the whole case. It in fact takes the whole process of recruitment.
No, but the conclusion that it is tainted cannot be arrived at on the basis of the tainted evidence. If the evidence is tainted, how do we come to the conclusion that the examination or selection is tainted? With the greatest respect, what my lords have pointed out shows that the evidence is not authentic. If the evidence is not authentic, one can't draw a conclusion that the appointments are bad. The entirety of the appointments are bad. But that with the greatest respect, we're doing injustice.
Is a double-edged sword which may hurt you.
I'm sorry, no?
The argument that you are raising is a double-edged sword. It may hurt your client.
I am respectfully submitting. Today, prosecution has been initiated. The genuineness of these certificates, authenticity of documents, etc., are all to be gone into there. Today, this conclusion which has been arrived at on the basis of which our appointments have been set aside on a wholesale manner, that cannot possibly be substantiated by this kind of evidence. That is a matter which is going to be gone into in the prosecution. Kindly, therefore, await that. Do not go ahead. Otherwise, I will demonstrate how these the authenticity of these documents have not been established, and therefore, on that basis, please do not afford. High Court, in my respectful submission, has failed to carry out the mandate of this Honourable Court's direction of 9th November. That is the principal submission that I want to make. Therefore, this is a matter which needs consideration on that account. I want to show those.
Okay, show us the 9th November order.
Yes, page 734.
And the report of the CBI.
Yes, page 734.
734,
I believe, minute of the common compilation. Yes, volume 3.
Yes, please.
This Honourable Bench of this Honourable Court, after hearing substantially, kindly have a look at the order passed.
What is the date of the order? 9th
November.
November 23.
9th November 2023.
23. Yes, please.
Yes.
Go down to the relevant portion.
I'm sorry.
Go to the relevant portion.
Yes, ma'am. Relevant portion, para 5. Main argument, so far as this batch of proceedings are concerned, have revolved around the admissibility of certain scanned copies of OMR sheets. The High Court found...
No, this is not required. To be verified 65B certificate is not really the main question.
No, I'm not even on the...
Down to that.
I'm not even on 65B certificate. I'm on authenticity. High Court found substantial difference between the evaluation records lying with the authority and the performance of the candidates reflected in these scanned OMR sheets. CBI claims to have recovered the pen drive from an... At that time, the argument was about a pen drive. Today, it's completely different. Pen drive from an ex-employee of the agency, which was entrusted with the task of evaluation of the OMR sheet. Employees whose services are sought to be terminated questioned the authenticity of these scanned images, and it is also the case...
No, this is an averment based because CBI may not be a party over here. No, CBI may not have appeared on 9th of November. May not have appeared on 9th of November.
CBI appeared. CBI appeared.
Okay, fine.
CBI had appeared and made.
May not have filed the counter at that stage, so somebody must have said CBI has recovered, because what is stated is CBI claims to have.
Some of my colleagues.
Anyway, read further. Read further, please.
No, ASC, Mr. Raju had appeared actually. No, I think out of 3.
Okay, fine. Read further.
Yes, Mr. Raju, no, it's there in paragraph. Mr. Raju Leonard, additional solicitor, has submitted the category 4 reports which are all.
Okay, read further.
Yes. Now, paragraph 5.
Just go up a little, we'll read that sentence itself.
Yes. Now, kindly see, in our opinion, para 8.
Yes.
May I read para 7 and 8?
Yes, please.
We have heard the submissions made by the Learned Senior Counsel and Learned Additional Solicitor General opinion for the respective parties, and are of the view that the substantive hearing of all the proceedings which has generated this set of appeal petitions before this court ought to be conducted by the High Court only. We are apprised that all the petitions from these so except so are still pending before the High Court. We have briefly described the nature of orders being passed by the High Court. In our opinion, piecemeal proceedings are not warranted in relation to the disputes of this dimension, and termination of service can take the interim stage before the final report of the petition also ought to have been avoided. Having regard to the nature of the controversy involved in these proceedings, it was necessary for the High Court to examine the admissibility of the OMR sheet images recovered by the CBI before placing full-scale reliance on them in directing termination of services of the concerned employees. This is not even done by the High Court. I will show. We are not suggesting that in cases of gross irregularities directed in appointment of certain individuals, termination at the interim stage is altogether impermissible. If some grave error in the appointment can be demonstrated, services can be terminated. But in the present set of proceedings, at this stage, unsuccessful candidates have not been able to make out such outstanding case at the interim stage. Investigation by the CBI is yet to be completed. Argument of corrupting the original OMR sheet is yet to be supported by cogent evidence. In none of the orders impugned before us, there is no clear-cut finding that there was distortion in the OMR sheet evaluation.
But then, they also state by West Bengal and SCC also parted. They didn't say that OMR sheets are not available. Why did they not say that?
No, but the Miller image.
1 minute, please. At this stage, the argument proceeds on the basis that it has to be collated with the original OMR sheets, the physical OMR sheets. They were as if they were.
Which is expected to be retained in the data.
They know the mirror image also.
This was the argument after here. This was a finding after here.
Just read that carefully. Just read that sentence carefully once again.
Today, at this stage, we are not sitting in judgment over these.
No, we are not. We are just referring to what was argued by the parties at that time.
Yes, and what was the conclusion? This is the argument of corrupting the original is said to be supported by cogent evidence. It's a finding.
Yes.
It's a finding. Even before there is a clear-cut finding that there was no clear-cut finding that was distortion in OMR sheet evaluation. Question of exercise of power under the aforesaid 3 rules also arise out of discovery of electronically stored OMR sheet. Previous allegations have been made of manipulation of records in exchange of money, but these allegations would have to be established through evidence. It is also our opinion, considering the importance of the points of law involved in these cases, number of persons who are likely by the outcome of these proceedings, and also having regard to the fact that majority of the petitions giving rise to these proceedings have strong attributes of public interest litigation, this court would consider it preferable to have these proceedings before heard by every division bench of the High Court. Then they go into Mr. Patwalia's argument, and then kindly now come to the directions issued in paragraph 12. Yes, yes. Kindly come to the top of page 741. Division bench may consider issuing a similar order only after authenticity of these images are established before it by applying the prevailing rules of evidence. We have consciously avoided in this order giving any finding on merits of the individual cases, lest such observation or findings influence the bench to be constituted for hearing of the subject controversy. We are, however, passing the order of protecting the employment of those already in service, as we are of the view that some element of status quo should be maintained. We accordingly direct the CBI to complete the investigation within 2 months and submit its reports before the High Court. CBI should also be at liberty to take such steps as may be lawful in pursuant of the investigation. We also direct that protection of to the appointment which is being accorded today shall continue for a period of 6 months to enable the division bench to finally adjudicate on the subject dispute. Proceedings in which the petitioner appellants have approached this court directly without being pleaded shall also have the right of audience before the High Court, but for this purpose, appropriate application shall have to be filed. As then leaves it to the division bench to decide the mode of
okay, fine, we have understood.
Okay. These are broadly the findings. Now, when the matter goes back, kindly now come to page 900. page 900.
Yes.
This is the proceedings of the court dated 19 January 2024.
Yes.
Yes. Requesting for inspection, etc. And Millard, please see Millard at page 902.
Yes.
I'm not reading the earlier part. We have considered the last two paragraphs. We have considered the rival contentions of the parties as also the order of Supreme Court. Honorable Supreme Court requires us to consider the issue as to whether the authenticity of images were established by applying the prevailing rules of evidence or not. Images are in electronic format. They are said to be contained in the 3 electronic devices, again claimed to be seized by the CBA from an employee of NISA, an entity which was, who was entrusted with the scanning and evaluation of the OMR sheet, wholly without prejudice to the rights and contentions of the party. We deem it appropriate to direct the CBI to produce electronic devices seized from the employee of NISA on January 24, 2024. It is submitted by counsel, a learned Deputy Solicitor General, that seized electronic devices were sent to Central Forensic Science. CBI retained a copy of the contents of such devices. CBI shall preferably produce electronic devices seized from their. No, it was never produced. They were said to be lying with CFSL, never produced before the High Court. CBI shall also produce the original certificate issued by the ex-employee of NISA, annexed to the affidavit of CBI. On that day, when this matter came up, a photocopy had been filed. Therefore, they were asked to produce the original certificate issued by the ex-employee. School Service Commission will also certify and produce the data available with them with regard to the 4 categories of cases before us on the next day. Again, same direction with regard to inspection of such produced materials. Materials produced will apply. These directions will cover all categories of cases that are being heard here. Issue as right of cross-examination will be considered even when raised by any individual part. Then, we go to the next proceeding, which are at page 954, that is the 24th January, 5 days thereafter. 954.
Yes.
Yes. Exception to the affidavit of Central Bureau of Investigation already filed in court be taken on record. At the commencement of hearing, Mr. Vikas Rangan Bhattacharya, Learned Senior Counsel appearing for.
Okay. Some logistics. We'd like your side to conclude by 3 o'clock. So, whoever needs.
Lord, I'll pray for 10 minutes, Lord. I'm for untainted candidates whose name has not been found anywhere in any of the.
Whatever it is, please do not repeat. We will continue
No repetition.
on this side to 3 o'clock. Please distribute the time how you want to do it.
All of us have also filed submissions, so we'll advert to that and finish it past 10 minutes.
If you have anything else to say other than what has been said, you can certainly take time.
Yes.
But do not repeat.
Yes, ma'am. Yes.
Now, please, we have made it very clear. Whoever, because we like to have it for about an hour so that we can conclude if possible today. Otherwise, we'll continue tomorrow.
Very well.
Lord, in Mr. Bhushan,
Yes.
let me say at the outset, we have not been entertaining any contempt petitions. In fact, all of them are pending.
Parliament.
Any notice of any of
Parliament.
We have not been entertaining any of them.
Pardon, Lord?
We have not been entertaining any contempt petition or applications. What we have been directing is, wherever there is an issue, please approach the authorities to decide. Because otherwise we'll be flooded.
Actually, what has been happening, I'll just
We'll be flooded with matters over.
we have approached.
Then please approach the High Court after that.
Pardon, Lord?
Please approach the High Court.
But it is your Lordship's order.
I know that.
Just see the terms of the order.
We have seen that, Mr. Bhushan. There are so many matters of this nature which are coming before us. It will be impossible for us to deal with them.
I understand. But if your Lordship directs,
we permit you to move that.
this will actually, my Lord, this will go on unless this court cracks the whip even in one case.
No, Mr. Bhushan, we will not be able to do it. There are matters coming from both the sides. There are issues coming from both the sides. We have not done it even in earlier matters, and I will not take it.
But Lord, this is so serious.
Mr. Bhushan, other matters were equally serious. We managed to control it by passing those orders. Several cases we have been able to, and in fact, there is such anything.
The problem is, Lord, this is going on repeatedly for the
Mr.
last.
Bhushan, we are aware of it. We are keeping it track of it. Many cases we have been able to solve them. Mr. Natraj, you are appearing in this matter?
Please, yes, I'm here.
Mr. Natraj,
Yes, I'm here.
Just please tell the authorities to keep a watch. They are already.
Yes.
That they must keep a track of what is happening. Video recording, if it is required, that has to be done. The nodal officers must keep a track of what is happening.
Please, we'll do that. We'll do that. We'll take
The bare fact that we are not entertaining the contempt doesn't mean that
That's right.
the violation take place of our order.
Yes.
Because we rarely speaking, this is order saying that no offense should be committed. There are sometimes there are no offenses committed. We can't.
Not
Right.
the preliminary nature of this court's order was.
Mr. Bhushan, we are aware of that. Don't keep on repeating. We can't do that. We have not. It's not the first case. There are a number of cases where we will not issue.
But if it continues to go on,
Mr. Bhushan, we have a problem. We are not saying there is no problem. That's why we kept the matter pending. But then we have to also accept that all matters cannot come to the apex court.
But not
If I entertain one, I'll have to entertain all.
No.
Sorry, Mr. Bhushan.
It will stop.
No, Mr. Bhushan.
Once the court will
We
relax
are trying to stop it in our
one case, it will stop.
No, Mr. Bhushan. Right now.
Somebody or the
Bhushan, that's
held accountable.
Mr. Bhushan, that's right. We are not inclined to entertain the present petition and leave it open to the petitioner to to the applicants to take recourse. Applicant petitioners to take recourse to appropriate remedies as are available to the law. At the same time, we deem it appropriate to reiterate our earlier orders which require the district authorities, including the nodal officers, to take all precautionary and precautionary as well as other measures. There is acknowledgement on
The email and with the acknowledgement. In fact, they did not file a parawise reply to our petition.
Maybe, but in the
And we annex it.
The High Court also says the reply has not been filed.
No, kindly see.
Just 1 minute. Let's read it.
Exhibit N.
Just 1 minute, please.
Not page 332.
Just 1 minute, please.
Yes, sir. Thank you.
Number 3 is what is this? You provide a forget about 1 and 2. The third one is not complied. You say, please provide me a format of affidavit. What is this? Affidavit can be provided. Can be written by anybody.
In these tenders, they have lot of
not
annexures and
the one, even one is enough to show you off. You say, please provide me a content of affidavit. You can draft an affidavit yourself. Others have done it also. Sorry.
Just kindly see, Lord.
No, Mr. Even one, you have the first not filed it, the third is certainly not compliant. Sorry.
Your Lordship may see page 140, my Lord. They say that it has to be in a format.
Format?
Kindly see, 159.
You could have, others have done it, no? Others could have done it, you could have given that.
They should have responded, my Lord.
No.
They should have responded. And kindly see, my Lord, under the procedure, the requirement was that they will upload the rejection of technical bid. After 1 week, they will open at least minimum 1 week. They open within 7 minutes of that. The whole purpose of that was,
that will not
kindly see, the whole purpose was that if there is any clarification required, we are able to.
No, they issued, the very fact that they must have opened the technical bid, therefore they came to know that your papers were lacking, therefore they asked you for those details.
Lord, after that, after the technical bid rejection, they are supposed to give reasons. This is the rule. This is the tender conduct. They will give the grounds. They don't communicate the grounds. And within minutes of that, my Lord, they open.
That has been dealt with, rightly. It's an administrative order. When we reject.
And June, my Lord, kindly see, June they had sought
the contract has been entered into, is working now.
My Lord, in fact, he is not even eligible on the face of it. The minimum requirement was 7 years. His earliest contract, which he has furnished, is 2021.
That's been dealt with in the future.
My Lord, with respect, that has not been dealt.
Sorry.
7 years, he's not having that clarification.
We are not inclined to interfere with the esteemed judgment of especially petition. Next day.
Matrix. My lords, in the morning, were saying that perhaps the bench was not aware when it was ordered in November that the original sheets had been destroyed. Please see page 577. On 6th December 2022, the statement had been made by the Commission that the original OMR sheets have been destroyed. Therefore, my lord, it was known even by 2022 and 2023 when the order was passed, my lord, the bench was aware of it. I just wanted to. Now, if I may continue, my lord, page 954 I was on.
Yes.
Please see, 954, at the commencement of hearing so and so. Now, he draws attention of the court, fifth line, to the contents of such affidavit and submits that in response to a right to information application made on February 24. School Service Commission by a writing dated January 18, 2024 stated that School Service Commission possesses the OMR sheet. He draws attention of the court to the photocopy of the OMR sheet as made over to Anindita Bera by the School Service Commission. He submits that the School Service Commission is in possession of the OMR sheet and therefore School Service Commission be directed to produce the same. I don't know. They completely conflicting. Now kindly come to page for 950, next page.
This will go against you, in fact.
No, if it is there, the best.
Oh, completely. When they make the statement that the State Service Commission is in possession.
I am now being damned without being heard.
No, you're not. You're being heard over here.
Yeah. I'm grateful to my Lord for hearing me. Page 955. My last full line. He submits the Honorable Supreme Court restraint publication of OMR and the public following submits are required to be considered by the court prior to deciding the admissibility of evidence. Affidavit filed today should not be taken out of court. So-called OMR sheet annexed should not be taken as side to side. I'm skipping one paragraph. Learned Deputy Solicitor General submits had seized electronic devices were sent for forensic examination to Hyderabad. I'm sorry.
For 955.
Next. Learned Deputy, page 956.
956.
Yes, sir. Third paragraph. Learned Deputy Solicitor General submits that seized electronic devices were sent for forensic science examination to Hyderabad. And the Central Forensic Science Laboratory at Hyderabad, who by writing declined to examine the same, since the materials containing the electronic devices were voluminous in nature, Hyderabad at CFSL was withdrawing such materials. He submits are expected to reach. Therefore, no examination. See, then kindly come to page 1013. This is the proceedings of 5th February. When the original of 65D certificate is produced to file, etc. I'll skip that part of it. Please go over to page 1015. Learned advocate appearing for the School Service Commission files a sealed envelope containing hard copies of candidates in the panel and waiting list showing OMR marks. 4 compact lists with regard to 4 categories of candidates showing OMR server marks of all candidates. These be kept with the records. Admissibility of these evidence will be decided at the hearing along with other issues. In view of the order of the Honorable Supreme Court, number of matters pending and the issues required to be decided as specified by the Honorable Supreme Court, we propose to hear the matters on the basis of affidavit evidence. In such circumstances, it would be appropriate to permit the opposing parties and one opportunity to use affidavit. Tainted person. I am saying there is no material to show that I am tainted.
Probably even the prosecution.
The problem is that my lords keep repeating every day that everybody should be given an opportunity. Here I am, before my lord, saying that there is no material which can be relied upon to say that I am tainted. And nobody
can that in all the cases of those 20 lakh students, applications should have been number 1. Number 2, that 25,000 should have been issued show cause notice. Number 3, at least those 15 or 30,000 or 4 or 5,000 whose marks were found to be manipulated. How can that be possible?
Somebody has to demonstrate, either the petitioner or CBI.
They have demonstrated, please. Look, we have to believe SEC themselves say yes, they are wrongdoing. They are not hiding that. The board also says there is wrongdoing. The ones who are
the authorities who are supposed to have polluted.
The CBI also says there is wrongdoing.
CBI is the person.
We are going back, we confess.
The authorities who are supposed to have colluded in this, they say they are okay. What CBI says is gospel truth.
In fact, they would have to concede because they were cornered. That's all. That's next.
They want to extricate themselves from this. There is nothing to demonstrate that we are in any manner tainted. That's a minute that somebody has to take on the onus. Nobody has produced any document. That we have written the exam, we have passed, we have got good marks, we have been selected, we have been appointed, we are functioning. Now we are being thrown out without even anything being proved against us. Now kindly see page 1016. So far as the prayer of Deputy Solicitor General with regard to original electronic devices is concerned, it would be appropriate to permit the CBI to produce such originals with CFSL Calcutta. Let they were to be produced, then who require inspection of OMR sheets may send such requisition. Now kindly come to the judgment. I have given the affidavit pages. Our written submissions elaborately deal with each one of the objections. They are at page 2868 onward. 2868 onward. None of this is considered. Kindly now come to page 210. 210.
Yes.
Let para 240 the chart.
Yes.
That this doesn't match. CBI by SSC has submitted a statistical report. CBI gives another report. Not these do not tally. This contains one number. There is another number. Kindly see compare this with page 248. Para 305. The numbers given here or do not tally with, there is no manipulation of 950 numbers. Here it says 993. There is nothing matching in regard to any one of these. Now please see page 273. Para 273. SSC, para 273 at page 229 or 227. I have 227.
Para 273 at page number?
I think either 227 or 229. 227, yes. SSC had at no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegalities of recommendations, but had limited it itself. Therefore, SSC has not checked. Now, kindly come to page 288, or para 288. Now, kindly start with para 286. Order of remand dated November 9, 2023, passed by Supreme Court in relation to present matter, has required us to pronounce on the admissibility of data contained in the 3 hard disks. Issue of admissibility on the data contained in the 3 hard disks have been raised by the beneficiary of the fraud. You have already come to a conclusion, I am the beneficiary of the fraud, without even deciding on the admissibility. Kindly look at this, therefore I am condemned. And then thereafter, I put down a peg. And none of the Article 12 authorities had ever disputed the genuineness, veracity, authenticity and legality of data contained in the... If they don't, I have disputed, I have filed affidavits, I have produced material.
How can you dispute that? That's just checking of mark sheet, all that you could have...
I am saying, this is not mine. What you are showing as OMR sheet.
Your OMR sheet is something different from the marks you have obtained.
Therefore,
you are not privy to that.
There has to be some method of proving that I have not secured the marks which I claim I have got.
They have examined
that.
You are in one of those categories where the marks were different from the OMR sheet?
Yes. No, I am in the second set of category where Mr. Jaideep Gupta has claimed the affidavit, not the one who jumped. Not the one who has been taken through the back door, but whose marks don't match with the OMR. Yeah, that's right. 288.
You are the one whose marks don't match, no?
How am I? Can I be asked to prove? Can the onus be put on me?
No, there's no onus on you. Because you were never aware of the marks also, so you never aware of it.
Therefore, how do I disprove? How do I prove that?
He was aware marks were published. I'm also in the same category. I'll just take 5 minutes after him. But marks were published.
Marks were published, but you're not the marker.
I'll respond after he finishes.
You're not the checker.
Just respond after.
Yeah.
You're not the one who checked it.
I'm also in the same category, but I'm going to
good.
Completely different suggestion. I'll deal with it after.
Para 288. SSC had accepted such data, acted upon it, found manipulation illegalities of the OMR sheet, proceeded on the basis of findings, it had utilized such data. Therefore, they say, we will act on it. In my respectful submission, we dispute it, we deal with it in our affidavit. That's the only opportunity given to us, nothing else. We have put in our written submission, none of those are considered. And we will kindly now come to page para 294.
Yes.
In our view, the fact that the 3 hard disks contain data related to 4 categories of selection process conducted by SSC had proved by whom? By SSC and state making admissions with regard to in the application filing the writ petition and by the court. And
you understood your argument that you don't believe that the SCC's acceptance that there is wrongdoing is correct. Though they themselves say we are the checkers, but we made mistakes. We have done some conflict. They don't accept it. Because according to you, you never gave the exam, but you did not.
No. We gave the exam, we have been selected. We have got the mark.
The only thing is because you gave the exam, so therefore don't believe the SSC who themselves.
No, we gave the exam.
Not only that, there have been 2 committees nominated. The 2 committees also.
No, they didn't go into the others. They went into some other set of
committees. They are for Group C and Group D, not for assistant teachers. So there are 4 groups. Group C.
He's in Group C. He's not in Group C.
I'm in the group
assistant.
level 9 and 10 and group C. But level 9 and 10 I am appealing.
But
Level 9.
the committee who went is wrong. The SSC who accepts is wrong. CBI who has done the investigation is wrong. The court which has gone into that situation of reference to 65B certificate is wrong.
The CBI therefore finds.
I don't get your opportunity.
Kindly see the anomalous situation.
That's all, please.
Let's see the anomalous situation. CBI finds government, SSC and board have colluded.
No, that's all. Next somebody. Anything else? I don't
Let
get
para,
you.
let para 307, in my respectful submission, all the fact that the proof, according to them, all the relevant parties have admitted. Therefore, I am not even a relevant party. I am the affected party. My submission is not considered, and all the relevant parties have admitted.
You are the affected party, not the relevant party.
Very well.
Sir, just give me 5 minutes. I will take 5 minutes. Yeah. It will take more than 5 minutes. Let me try to persuade him on the one point.
The whole issue is the court finds, the board doesn't find, the government doesn't find. The court finds for the first time that my marks, there is a mismatch. What is the starting point of that mismatch? The OMR sheets recovered from this Mr. Pankaj. That is the whole basis of saying that there is a mismatch. Otherwise, there is no other basis of saying that there is a mismatch. Now, please have page 305. I just want to read that CBI affidavit. That can this OMR sheet be at all relied upon? Because everybody today says there is a mismatch, but the basis of everybody saying is because what the board says, board doesn't have OMR sheets, board has destroyed those sheets, board probably has some score or doesn't have some score is not very clear. Assuming that the board has a total score and an OMR sheet is recovered and that score is not tallying with the OMR sheet record, and therefore it is said that there is a mismatch. Now please see just 4 paras of that affidavit. Now, according to me, this affidavit at this stage, which is merely part of investigation, cannot be relied upon. The whole, your lordships just observed when my learned friend was arguing that every authority says that there is a mismatch. But the point is, every authority is saying on the basis of the same recovery from that gentleman. And that gentleman in his 65B certificate says, to the best of my knowledge, this is okay. 25,000 people cannot be ousted on that basis, Lord. The facts are, the assistant teacher process starts in 2016. In January 2019, we are appointed, we are working. Up to August 22, there is no challenge. The first writ petition is filed in August 22 after almost 3 years. In that writ petition, we are not made parties. At some stage of proceeding of that writ petition, the court says, let there be a CBI investigation. We are still not parties. Ultimately, my lord, on one fine day, the court passes an order on 2nd April 2023. The court passes the first order on 2nd April 2023, directing the board, 2nd February 2023, directing the board to exercise power under Rule 17. Rule 17 is a rule where if the board makes a recommendation, then that recommendation the board is entitled to withdraw. Recommendation was made in 5 years before this order was passed. The court tells the board, the commission, when it is of the opinion recommendations were made mistakenly or erroneously, it is obliged to exercise the power under Rule 17. The court says, you please look into it and exercise power. The board then comes and files an affidavit, yes, we will exercise the power. The court in that second order says, you don't need to hear them. The board says, yes, I don't need to hear them. When we get to know this is happening, we file an application to be impleaded before the single bench. The single bench rejects our application for impleadment. We go to the division bench. The division bench says there are too many of you. Some of you can be impleaded in representative capacity, but so far as 17 direction is concerned, we are not staying it. 1st March 2023 is the order of the division bench 3. Over 5 years after we are appointed, we are thrown out. So, my lord, this is, it is in my list of dates, my lord, I will give the page numbers to your lordships in a short submission of 2 pages. So, this is what has happened. We come to this court by way of a writ petition, by way of appeal against those orders. This court stays the operation of our termination, then remands the matter back, my lord, and that order of remand has been read, my lord. But I want to read 2 parts of that remand order, my lord, in my paper book. That is at page 629. I am in this Gopinath Bhanja, my lord, SLP number 9637. Compilation 734. Compilation page 734. Please have para 734. Please have para 8 of this order. Volume 3. The remand order is not complied with.
So what is confronting the court when the remand order is made is a person who is appointed in January 2019 is thrown out by the board just in a day. And what your lordship says is, para 8 I want to read, my lord, of this order. Para 8. Please have this with you. Two things the court had to do. Neither of the two have been done. I will read. Para 8. In our opinion, piecemeal proceedings are not warranted relating to disputes of this dimension and termination of service.
Have read it.
All right, just one line. It was necessary for the High Court to examine the admissibility of the OMR sheet recovered by the CBI.
They have done that. They have done that.
No, there is not a single line. My learned friends will show to your lordships. I can't show a negative.
They have done that. They have relied upon the statement of the
CBI affidavit.
CBI affidavit, which relies upon the statement of the data. Without.
Just want to press that. Full-scale reliance. My will show your lordships where the High Court examines this aspect.
Yeah, please. One thing. The OMR sheets have various details mentioned.
I'm just going to read that.
OMR sheets have various details which is there. Do you think those details are not matching? They'll match those. They would have matched it. They would have matched it with the SCC will be aware of the OMR sheet which was circulated at that time given to the student. We were worried on that score.
May I respond?
OMR sheets have been changed or not?
May I respond?
And nobody has. The person from whom they have collected the OMR, he is himself getting into a problem.
SSC, yeah, he's an accused now. SSC,
so really
SSC in its proceedings have recorded. All our record is destroyed.
You want to believe us that actually?
No, my lord, just allow me to just proceed. Now, I'm conscious of what has fallen from your lordships. That is weighing in your lordship's mind, my lord. I have been seeing it, and unless I can beat that I'm going to get nowhere. So, my lord, I'm just going to come to that straight away. But just one more line. So, first thing which remand order said, first please examine whether it is at all admissible. Because, my lord, right from the Taj Trapezium and earlier judgments your lordships have said, these status reports are investigations. They are not gospel truth. Unless they are tried unless they are tested in a trial, you cannot base findings on them. That's what your lordships have said. So, this is only an investigation report. Now, second which the court said, para 10, in the course of hearing.
I had a impression that those two cases they were already dismissed.
Which ones were?
Some of the cases.
No, we have challenged, 1 minute, we have challenged 65B certificate in the High Court saying you cannot rely on it. Those writs are segregated and they are still pending in the High Court. My writ which I had challenged 65B, yes. High Court says I segregate it, it is still pending. Where your lordship said before you do anything, first please decide that.
Okay.
Now this is one. Second, in the course, all right, 1 minute. In the course of hearing before us, Mr. Patwalia raised the point that division bench has come to a finding that there was no necessity of hearing while applying Rule 17, having regard to the quality of the evidence that was there before the division bench. While taking that view, we are of the opinion that the question needs to be examined afresh. Let the question also be addressed by the division bench of the High Court afresh. Now the court says 17 I am not going into. 65B I am not going into. Two questions which the division bench remanded, your lordships remanded, court says I am not going into. Now we will just have that CBI status report of that 65B certificate. Because according to me, just kindly have, I'm just going to take 5 more minutes. Please have page para 305 of the High Court judgment with me. Your lordship has seen it earlier. What I'm trying to point out is, just have it with me, Lord. Well, this record cannot be relied for anything. It is a 1, 2, 3, 4, 5 party record conveniently found in somebody's residence. And that man is not even working with NISA. And there is no way he could have had this record. And after getting the record, filing it in the High Court, our termination takes place. Now he is made an accused. And tomorrow if he says that, if he resigns from his statement and says, this is not genuine, I have made it myself, or there is manipulation, the damage to us is done already because the trial has yet to start. So therefore, just see, my lord, how just bear with me for these 3-4 paras, because it's a whole make or break so far as we are concerned, my lord. These 3-4 paras. Just kindly see. During investigation, now I'm reading the extract of the affidavit. Affidavit is on the record. In the affidavit, 5 places the CBI says investigation is on, during investigation, this is part of investigation. So many places it is said. Now, during investigation, it was revealed West Bengal Central School Service Commission had awarded work order to NISA for scanning and evaluation of the record. This is para 3. Para 4. Investigation has referred that Puneet Kumar was the director and Niladri Das was the vice president. It has been established during investigation that Niladri Das used to do it, my lord. We can leave that. Come to para 5. Investigation has established that scanning of OMR sheets was undertaken by NISA at the West Bengal Selection Board office under direct supervision of Niladri Das in the presence of officials. It has further been established NISA had further given Messrs. Data Scantech, who remained present after completion of scanning. The processed data in the form of scanned images, scanned data were handed over by Data Scantech to NISA, who took the same to their office located in Noida, leaving the hard copies of OMR sheets in the office of the board. Board handed over their answer keys in respect of all subjects for evaluation of OMR responses. I pose here. So far, nothing has happened. That hard OMR sheet photo is scanned by this Data Scantech. It is given to NISA. The key is also given to NISA. Now, my lord, para 6. While scanning the sheets by Data Scantech on behalf of NISA, 2 DAT files were recorded. My lord, 7 also your lordship may leave, my lord. Then 9. During investigation, para 9 at page 239. During investigation, the server database of the commission was seized by the CBI. All data pertaining to selection of so-and-so. That during the investigation of the case, 3 hard disks were recovered on 15-16 September 2022 from the residence of Pankaj Bansal. Now, the selection process is in 16-17. You are recovering in 2022. In the meantime, what has happened? Data Scantech has bifurcated. 2 partners have separated. This Pankaj went with the second partner. He was no longer with NISA. Then the second partner's company also went defunct. Then this Pankaj joined a third company. And now he is giving a 65p certificate as an employee of a third company for ND Infotech or whatever, from something which is recovered from his residence. And this is the gospel truth on which everybody, the board is coming and saying, yes, there is a mismatch. Lord, it is too specific. Okay, it is too far-fetched.
Lord, I will since 10:30 I am waiting. I will take 5 minutes.
You are the same category of Mr. Patwalia's right?
My lord, may I just say this? I have a suggestion.
I would submit, Lord, your lordship may appoint some good agency to
My lord, I'm not going to argue or say anything about the facts. Facts are before your lordships. You've heard all the facts. The point I want to make the point I want to make is very simple, my lord. Without a doubt, your lordship has seen it. I'm not going into the evidentiary value, this value, that value. I'm not going into anything. Admittedly, there is some material. Admittedly, that material points to certain amount of manipulations. I'm just going on it at the worst, my lords, is what can be taken. The 2 questions which would then arise to your lordships is, what is the consequence? Now, my whole point on this is, when just see this one submission of the SEC. I'm going on them. As your lordship, you're putting it to others who are arguing it. What do you have to say when the SEC itself has said so? Please see the submission. Just see that alone. Volume 6. Kindly, my lords, turn to page 16. It starts at page 15. Kindly turn to page 16, volume 6.
Yes.
Paragraph 6. It is stated that on a careful scrutiny, my lord, let me say straight away, I'm for these assistant teachers of 9 and 10.
You are also calling the tainted list?
That's why I want to read what is the tainted list to your lordships. That's why I'm trying to say.
What is this document?
My lord, this is the SEC submission on the commissions. My lords, kindly see paragraph 6. It is stated that on a careful scrutiny, Commission prima facie noticed that there are candidates who can be said to have appeared to have jumped their ranks. That is to say, people having lower rank have been preferred over persons having higher rank. It was also prima facie seen that some candidates had been recommended an appointment without being in the panel or appointed without recommendation. Number of such candidates are as follows. Assistant teachers, rank jumped, out of panel but appointed 185. My lords, I'm not there in that category at all. Then my lords, I'm not on. Paragraph 7 goes on what? CBI, because your lordship said there was a concurrence between SEC and CBI. This is what SEC says. CBI says, even in the investigation, it has been found that some appointments, even in the investigation by CBI, it has been allegedly found that some appointments were alleged to be manipulated by allegedly manipulating OMR scores, which are part of that. And that is where this 808 comes in. Not 952, as it was pointed out, it is 808 on who were appointed. So the point I'm trying to make, my lords, is whatever it is, dissimilars should not be treated similarly. What has happened is, on the strength of this, the High Court has thrown out everyone, 13,000 people. Now, my own submission to your lordship, subject to what you feel, my lords, is that SEC has found that these category of people who are not at all in the panel but still appointed or jumped rank, my lord, I can understand. But regarding others who are at that evidentiary stage, surely, my lords, we will have to be subject to whatever is decided finally, whatever this evidence brings out, whatever it finally brings out and whatever the inquiries are pursuant to this. But they cannot be treated. 6 and 7. 7 is based on what CBI has said, not what SEC is saying. 6 is what SEC has found after going through the CBI reports. Now, 6 I can understand is one category, but you cannot mulch 7 in that category and say even 7 requires no inquiry whatsoever. That is all I want to submit to my lords is, number 1, let the baby not be thrown out with the bathwater. Because of this, let everything not be set aside. 2, amongst those who are found to have in some way possibly been favored here or there, please deal with them. But my lords, it can't be dealt with that I'm peremptorily thrown out as item 6 would be peremptorily thrown out. This is a subject matter of some kind of inquiry. All I'm seeking is that regarding these people, let there be some kind of inquiry. We don't have a huge amount here. It's only those people, and I'm talking about the paragraph 7. That's all I'm seeking, my lords. And please do not treat dissimilar similarly is all that I'm seeking of your lordships finally here. Because we have so many different categories here. We have those, my lords, who are in the 13,000, those who are in the L. That's it, my lords. And therefore, I'm only submitting, and my suggestion is only this to your lordships. Please, my lords, mold the relief accordingly based on who is in which category. But surely people whom SCC has not found have to have an opportunity at least, if nothing else. I'm not saying for everything. I'm not pleading natural justice. I'm not pleading. But surely it can await some judging of that evidentiary content. That is all I'm saying, my lords. Nothing else.
My lord, I will submit that, my lord. Kindly see section 45A of the Evidence Act. This certificate is not there. Section 45A of the Evidence Act speaks about when in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer, resource or any other electronic or digital form. The opinion of the examiner of electronic evidence referred to section 79A of the Information Technology Act is a relevant fact. Now, these section 79A and section 45A, 79A of the Information Technology Act and section 45A of the Evidence Act were amended on the same day. And section 79A of the Evidence Act says the central government may, for the purpose of providing expert opinion and on electronic form evidence before any court or other authority, specify by notification in the official gazette any department, body or agency in the central government or a state government as an examiner of electronic evidence. Now, this has been done there by the central government. Different laboratory has been established. Now, there is no certificate passed for the formation of opinion or the taking into its relevant fact. Section 45A of the Evidence Act, it has not been complied with. My second submission would be, my lord, if your lordship see the certificate.
What it says is a relevant fact. It doesn't give the mode of proof base. It's a relevant fact. What is the difference between a relevant fact? Relevant fact means it's a relevant for the purpose of adjudication. Evidence fact also doesn't apply to adjudication. Let's not go around in a tangent.
But earlier the order which has been delivered by this court, there the Evidence Act has been
the Evidence Act doesn't apply.
There
are provisions of Evidence Act which can be taken into account, but it's not perfectly applicable.
65B4.
There the CFSL report has been obtained. It's a relevant. All that it says is a relevant fact. That's it.
It is not obtained. It has not been obtained.
1 minute. CFSL report has been obtained.
It has not obtained. It has not obtained.
There's no FSL.
CFSL report has not been obtained.
I think forensic examination of has been done. The mega data has been there. You said you're wrong on that.
It has not been obtained. Kindly.
It has been obtained. It was sent to the forensic examination Calcutta. That
it was returned. It has not been recorded. Declined. They have declined that they would not do it.
Okay. CFSL Hyderabad declined, not Kolkata.
Pardon me?
CFSL Hyderabad declined.
That's right.
Thereafter, it seems to have gone to Kolkata CFSL.
Thereafter, not in any other laboratory.
The finding that the hard drives have not been contaminated.
Thereafter, it has been not sent to any other laboratory.
Okay, fine. There's the difference between a relevant fact and adversity.
That's right. Kindly say the second point.
Experts are never the only way to prove.
Kindly say 65 2B4. 2B4 speaks about who will not give this certificate. Not everyone. Kindly say this. I am coming to very relevant portion. I am not reading in 65 4B.
The one who downloads gets the certificate.
My lord?
The one who downloads gets the certificate.
No.
Yes, that's the law.
Yes, no. Purporting. Kindly, just excuse me.
We have read 65 so many times.
I understand, Kindly excuse me. Kindly excuse me. The convention in its subsection 2 relate as purporting to be signed by a person occupying a responsible official position.
Correct.
Impression to the coast.
So from whose position the CDs were recovered? The hard disk were recovered? From whose position the hard disk were recovered?
Data into operator. According, but kindly read the CBI report. Whether Pankaj Bansal's name is mentioned there.
Okay.
The two other persons, who are the persons who in charge of the operation? They were there. Certificate has not been obtained from them. Certificate has been obtained from a person who has left the company and went to someone. This is there from the report itself, Miller.
Not even in fact 65B certificate is not required because it's the original document here. The original hard drive is taken.
No, it's not an original document.
Which does. That's what they are saying. It's so original.
This is not an original document. It's an email. Wbssc has.
1 minute, please. It's not required. Suppose email comes to you. Email comes to your computer. and you produce your laptop or your hard drive in the spot, 65B certificate is not required.
That's a
That's law. The next case, please. Next argument.
My lords, very briefly, on the point of originality, my lords.
Okay, one by one.
My lords, just a very brief point on the point of originality. My lords, the OMRs are essentially a sheet with dots on it. Now, they're generational dots.
Round markings, dots are given by
Precisely, my lords. Now, my lords, then what happens?
1,000 pages that were given to us yesterday, OMRs are there. This is at page 2826 of 118B. Volume 5B, page 2826.
Volume
5B, 2826. You don't have volume
28.
5B by the way.
Yes, my lord, it has been given.
There's no volume 5B in the compilation.
2826 of compilation miscellaneous volume 5B.
Now they must be changed the number.
2826.
2806 also. 2806 miscellaneous volume 5B.
Just scroll it. Just scroll it.
Scroll it.
My lords, so while they find that, the OMR, as my lords may imagine, we've all done multiple choice tests. That is the version of the email. Now, what is the hash value that they have compared? It is not the hash value of every individual OMR. What they are saying.
They cannot.
Okay.
It will be impossible. If they would have done that, but probably they must be contained in one file itself. And the hash values would have come when they checked it. What they have done is they compared hash values of two hard drives. So we know when the CBI council tells us whether the hash values included the date on which they were scanned, etc. or not.
From the metadata, as my lords had requested them. But my lords, when they extracted the data from the OMR into a .dat file, there is, and I researched this extensively, across the board there is admissions that there are generational losses. So for example, just to put it quite simply, when in, not today as much, but in 2019 or 2018, we used to convert PDFs into Word files. There were errors. Now my lords, used to convert PDFs into Word files. There were errors. Now my lords, what they've done is that they have got these response strings that they themselves created. And then you have these hash values with not one generational loss, but two, because there's the .dat file, that then becomes the .dbf file, a third file. And then you compare the hash values, my lord. And so the thing is that
you're supporting complete, you're in other words supporting the complete computation of the result.
No, my lords, what I'm saying is this. What I'm saying, my lords, is that of course all may not be well in the state of Denmark. Of course. That's just a
class C&D, AOV.
I'm in 9th and 10th.
9th and 10th, C&D.
No, not C&D. C is clerical. I'm an assistant teacher in C&D.
Okay, 9th and 10th.
I'm AT assistant teacher.
Tainted, not tainted. Tainted or not tainted?
My lords, I believe I am not tainted.
What's your belief? As per the order, do you fall in the tainted category?
My lords, as per the order, there are three types of tainted. And all three types of tainted are based on entirely different evidence.
Are you there?
So I am there in third category. So when we look at the
first third category, you got to jump in mark.
Where the OMR is being challenged. So my lords, what we are saying. My lords, if I may just point to the differential in the value of the evidence between people who are alleged to have jumped ranks.
You can break up any answer, even on pure facts or truth.
But my lord, raised a question earlier, if I may.
There are certain things which are quite apparent.
But my lord, the things that are apparent, the ex facie wrongdoing with the right
number. The sheets are there, the sheets are all there, the names are written, everything is there.
All I'm saying, let it face process. Let it go through some process. Either the criminal process, Pankaj Bansal is going to fall under cross-examination. Or my lords, let it go through the 2018 rules.
The untainted category.
First, let's deal with the tainted category, and then
I just want to make a
Then your lordship can prove that partly tainted or tainted. Then
not as per your belief, as per the judgment which you are tainted. Or not
Lords, maybe get back when the CBI comes back with the metadata. Maybe get back to my lords on this.
For us, please.
I'm grateful.
We are in the untainted category, which is not tainted. We are all untainted.
Okay. Tainted on this side, not tainted.
No, I'm untainted.
Okay, let's finish with the tainted first, then we go on to Okay, let's see.
No.
I'm representing you from separate categories of questions. One is group D, one is class 9.
I don't know what this means.
It means any report names are different allegations. In group D, they say that I'm not in the panel, and there's no recommendation given by the commission, where the board who's appointed me says commission in fact gave you their recommendation. Second category is rank jumping. Third, they say there was some tampering with your OMR, but commission says even if that 1 mark is taken care of, even then 31 candidates make it to the panel. I'm part of that 31 candidates. So there are 3 separate categories. My submission to your lordship today is as follows. What has the High Court done? The High Court has said, yes, there seems to be large-scale irregularities because of what has been said about the OMR sheets. Insofar as the rank jumping out of panel, there has been no discussion, nothing. Your lordship started off this hearing wondering if there's a possibility of segregation, and I'd like to address on that. Your lordship will see the commission's written submission has at page 17, your lordships, that is in volume number 6, page 17 of the commission's written submission. There is a table.
But you are allegedly in the tainted category. How will this help you?
I'll tell you lordships why. As far as there are 2 of the 3 categories, which are so-called rank jumping and so-called I did not get a recommendation from the commission. According to me, I got the recommendation from commission and there has been no rank jumping. Now, these 2 issues are purely factual and they can be segregated from OMR. As far as my omnibus submission is, if your lordship will consider that even the CBI, the commission, whichever figure your lordship...
There's no difficulty in that.
Yes.
As far as rank jump is concerned, it's simple. Your OMR sheet is available. They've given that soft copy. You can identify your OMR sheet. You know the marks which are there, the corrected scores. You know the suggested or you know the correct answers, and you also know the marks which you have been given for being selected. Where is the big deal?
So this, no, the big deal comes, no, your lordship, the big deal is, I'll tell you lordships.
Look, this is all difficult to decide.
Not at all. May I just make a submission? The marks are the same. In my category, my marks have not changed. The marks are same.
But you have been given more marks.
No. I have not been given. 2 of my 3 cases of no allegation of more.
What has happened?
That they have been given
appointment.
Somebody above them has not been given.
It's the allegation. Is the allegation. Now may I submit?
Rank because of marks, not because of the marks.
Rank jump, and no recommendation.
So my first submission to your lordship is, your lordship will see.
How do you get out then? Your marks are known.
No,
the marks are correct.
No, the CB.
1 minute, please. And the ones who are above you have not been given appointment. You have been given appointment.
That is an assumption.
I'm absolutely.
No, I'm not saying. Your lordship will just kindly hear me out. I'm not saying your lordship should confirm my appointment. All I'm saying is these are matters which ought to be relegated to the High Court because the High Court has not even gone into this. If very well they check my papers and they find yes, I have indeed jumped track.
Tried to argue, you could have argued.
He did.
How many marks did you get? As per the OMR sheet, how many marks did you get?
Lordship, I have different categories. So lordship, many of them have.
You would have simply filed an affidavit saying, as per the OMR sheet, my marks are shown.
But it was not considered.
1 minute, please. You should have simply filed an affidavit saying, my marks as per the OMR sheet as X, Y, Z. The minimum marks required for appointment were less than this. So therefore, my appointment was right. That's it.
Yes, precisely. Now, can I do this before the High Court? Because it has never been.
You should have done it before us.
But that was not, I'm sorry, Your Lordship, that is not the scope of these proceedings. Has to be a fact-finding authority. May I make a submission? Before the High Court, these submissions were raised.
Let's not go around for remand on this.
No. Okay, if Your Lordship will just see page 17 of the Commission's written submissions, table 2, where they themselves say how many are the OMR tainted candidates allegedly according to the Commission. Now, CBI may have a slightly exaggerated higher figure, right, wrong, I'm not going into it. My first submission to Your Lordship is, Your Lordship will kindly consider segregating those who are tainted by OMR sheet allegations as opposed to the other allegations. If all of them can thereafter get heard separately, even before Your Lordships, we will be in a position to...
We are asking you to please tell us if you have raised that point. We are not going to go into...
Your Lordship, in which case, as far as my...
You know the law, or the 41 Rule 27?
Yes, Your Lordship. In which case, Your Lordship, in one of my SLPs, which is Sanjukta Shashman, with Your Lordships today, item 1.55, I am part of 31 candidates. In this, Your Lordship will kindly see the allegation against me was that according to the sheets, I had got 1 mark extra, more than what I should have gotten. It is even the Commission's own submission before the High Court that us 31 of the various people whose marks were exaggerated were actually within the panel. I'll show you Lordships that, so far as the 31 candidates in Sanjukta, in fact, my petition is still pending in the High Court. The reason I have filed a leave because all my appointments have been set aside. My matter has been rendered infructuous by the order. That is precisely my problem. If my matter is pending before the High Court, but because in this other batch of OMR cases, the entire selection has been struck down. My case is as follows. My case is, I represent 31 candidates. We got interim protection. it was stated that the marks in my OMR sheet was a mark more than what I should have been given. Eventually, the commission before the High Court has...
a difference in marks.
Difference in marks. Yes, a difference in marks. And even after reducing the so-called 1 mark or whatever I got extra, the commission has taken the stand that 31 of us, and the commission is here and your lordship can hear them, are still part of the panel. We fall within the eligibility criteria. So, which is why we stand on a complete...
Criteria or within the cutoff zone?
Within the panel. I'm completely...
You will not be hit by, in your case, what
Yes.
is with you,
Yes.
if you are being hit by is the complete destruction of the selection process.
Yes,
That's the
absolutely.
complete ovation of-
Absolutely.
So
So in that sense, in Sanjukta Samir...
No, you are not in this side, you should be on that.
No, that is one of my 3 cases.
So you are not on both the sides.
Your Lordship, so this is that... Insofar as Group D is concerned, the allegation...
Okay, anybody else?
Milord, may I be permitted to, Milord?
Yes. I'm from dispatch category.
But I'm for Group D. I'm in the allegedly tainted people, Milord. Although I say I'm under the stay, I have the job right now. I'm not reporting to Milord.
Just to
So therefore, just a couple of more points, Milord. I'm so sorry, just a couple of more points. Milord, therefore, Milord, I want to give an overall consensus as to what it is my submission. That is the question that your lordships are deciding at this sort of interim stage, Milord, when the trial is...
Okay, in your case, the OMR sheet is available.
No, Milord, it's not.
1 minute, your OMR sheet will be available. The names are also mentioned. The signature of the candidate are also there. So then if it's not there, then you have participant to withdraw.
No, Milord, that is nobody's allegation, Milord.
Obvious.
At the time when I participated.
Okay, we'll take up.
And just a couple of more things. Just on the overall perspective.
That makes it work first. That is correct. That your OMR sheet is not even available.
That is for everyone, my lord, across the board. All OMR sheets that were uploaded, scanned and uploaded that time were mandatorily destroyed. For all
I'm not on that.
Yes.
But the OMR sheet which they have been able to retrieve from the hard drive, the OMR sheet is not included in that?
They are no.
Then why are you saying that they are not included?
No, I am saying that the original OMR sheet which were uploaded.
Forget it. The OMR sheets which have been uploaded include your OMR sheet.
Yes, my lord.
And
That is how I got the
you had to then file an affidavit. This is not my OMR sheet.
I'm sorry, my lord.
You could have filed an affidavit saying this is not my
I've
OMR
sent
sheet.
one affidavit, my lord.
This is not your OMR sheet?
No, my lord, it's not.
It's
That
not.
is everyone's case, my lord. The OMR
So none of you, all of you are saying these are not your OMR sheets.
I'm so sorry, my lord.
All of you are saying that these are not your OMR sheets.
My lord, I can speak for myself. But
No, you got 300 candidates.
Yes, my lord.
They are all saying they're not their OMR sheets.
Yes, the OMR sheets which were found in the hard disk, found with Pankaj Bansal, are not our OMR sheets.
Okay.
And I've said that on
Thank you for supporting that.
May I just... Milord, may I take...
So we are untainted, madam.
Some little later. Tainted ones.
Last submission.
Slightly tainted. So Rami, you are also slightly tainted.
My category is untainted as per para 6 of State Service Commission, tainted as per para 7 of CBI. My respectful submission is I respect
Which category? Sydney D, 9th and 10th or 10th or
11th and 12th, my lords. 11th and 12th. So therefore, as per State Service Commission, I don't fall foul. Para 6. As far as the other categories concerned, my lords, OMR, I adopt the submissions of Mr. Sundaram, my lords. That these require further investigation, these need to, and that was the submission of Ms. Padmanabhan also. I adopt both their submissions.
Milord, may I just take 2 minutes, Milord? I have a partner.
You also for tainted? Okay.
Milord, may I take 2 minutes, Milord? Milord, I have a partner going on, Milord. Sorry for this, seeking indulgence, Milord. Milord, mine is a case where we were working in the education department from 1999 till 2016 when this advertisement came. The system earlier in West Bengal was that there were 5 zones and you could be only put in one zone, you could not go all over. The rules were changed and 2016 allowed that you could be placed anywhere, even near your hometown. So, Milord, we took permission and we were granted to take the examination for the purpose of being taken. We were then again impaneled and our service books were, Milord, continued from before. Our salaries were fixed according to the old service and there is no taint on us, Milord. And we filed an application for intervention before the High Court. The High Court notes that the application is filed, argument is made, but does not go into it further. And we are, Milord, one person is going to retire this year, the coming year, 2025. And we are some 423 odd people, Milord. My petition number is 1.19, listed before your lordship today.
Okay, so, if we dismissed specially petition, in your case, we simply to say if you are already working, that's for them to decide.
No, we.
As a temporary worker or casual worker, whatever it is.
No, in the tainted list, we are not there at all.
We understand.
And we are continuing to work today.
Therefore, what we are saying is, you are not in the tainted list.
Yes.
But because we are annulling, we uphold the judgment and annul the recruitment process.
Yes.
Your services as they existed prior will not be disturbed.
Please, that's all. I'm very obliged for that observation. Very grateful.
We stand in the same footing as Mr. Ramesh Kumar.
Mr. Kumar has, my lord, I am in this, I am in similar category. I am completely untainted. I am nowhere, my lord, in 952 or 808 or anywhere. The issue is I am 1.72, my lord.
But
47.
were you working earlier?
Yes. I was employed. Somebody was
satisfied with what we have said, or you want more? Something more than that.
I support segregation, my lord. I am class 11.
That's our class. Our statement was subject to the condition in case we annul, except the annulment of recruitment.
My lord, secondly, my lord, I just wanted to add two more things. My lord, I just wanted the excess appointment and supernumerary post that was being argued that time. That only relates to, as per my instruction, Group C and Group D. This has nothing to do with class 11, 12 and 9, 10 teachers. And so that issue may not be brought in with the teachers, my lord. That's my respectful submission.
You must be a teacher.
I am teacher, my lord, class 11, 12 and page in volume 2 of my SLP, my lord. This is 1.72. I have given complete chart.
We have already said, if you want something more, we can understand. If you're satisfied with what we have said,
I'll take only 1 minute.
I'll
take only 1 minute.
One last question on segregation. My lord, since I am in Group D, the only allegation against Group D is that the OMR mismatch. Now, my lord, there is no allegation of gang jumping, etc. in my case. Therefore, my lord, I submit, if at all any segregation should be done in this case, it should be that the people against whom there are allegations of OMR mismatch, they should be allowed to continue for the simple reason that in order to distinguish what is a genuine OMR and what is not, what is being found with Bansal, only a trial where a forensic expert is examined will make that clear. Whereas that is not the case, it's not the complexity of the process required in the other cases of gang jumping, etc. That can be seen much more easily, because as per
that's all they said. Okay. Now that's over.
Untainted. I want to just place 5 minutes. 5 minutes. 5 minutes in a written.
I'll take only 1 minute.
I am untainted by all.
Okay, mismatch is tainted.
No,
okay, yes.
I am untainted by any reckoning. By any reckoning, I am untainted.
Okay,
just 5 minutes.
1 minute. Let it conclude after that.
Volume 6, page 92 is my written submission. Untainted according to CBI, according to everybody, according to the board, according to the government. Now just turn to page 92 of volume 6. I'll read 5 paras only. I'm done. 7-8 minutes.
Yes.
Joshua, got page 92?
Yes.
Now, the petitioners were bona fide applicants to a public advertisement for recruitment in 2016, participated in a competitive examination, received recommendations and were issued appointment letters. They were appointed validly and remained in undisturbed service between 18 and 19 prior to the expiry of the panel in December 19. We are class 9, 10 and class 11, 12 out of 4 categories on these assistant teachers which I have given in para 2. Para 3. No adverse action has been taken against me. This is very important. During the course of hearing before the Honorable High Court from 2021 onwards, until the interim direction was passed in the impugned judgment. It's going on for the last 3 years. Further, the petitioners did not feature in any of the list of tainted categories. Justice Kumar asked a direct question. I am giving an unequivocal answer. No category, no list by any entity. None. That were filed from time to time by CBI and the West Bengal Central School Service Commission before the Honorable Court, underscoring the soundness and legitimacy of the appointment and tenure. Thus, despite there being sufficient material before it to identify and separate the tainted from the untainted, such as the petitioner, the impugned judgment erred heavily by painting all candidates with a broad brush. Prior to the impugned order, I am nowhere in any list. It is also crucial that a vast majority of I am 10,000 persons working from 2018. Now, let us kindly come, and as I said, I'll just come to para 15. I'm skipping most of it. Well, I will come to para 15 now.
Yes.
The appointing authority and the recommending authority have taken a decision to sustain the entire selection. The expert body involved in the recruitment process found it fit to separate the tainted from the untainted. Why, Wallace? For a very simple reason in my case, which is given in para 16. There are 3 lists made available by the board and the CBI. These are the list of 775 candidates, revoked using Rule 17, both 9, 10 and 10, 11 classes. List of 942 whose OMRs were found by irregularities, nowhere on the list. I am nothing of this. List of 907 whose OMRs were found with irregularities for 11th and 12th. The first list pertains to the independent exercise carried out by the board of classes so-and-so, and this your lordship knows, fellows. Next, fourth line. Notably, the CBI had filed an investigation. This is very important, lordship, underline this, fellows. Saying that the investigation relating to all 4 categories was complete and charge sheets have been filed. So they found those 4 categories. I'm nowhere there. It's over. Then, even before the High Court, as far as illegalities are concerned, your lordship, I made a table. Your lordship has heard the OMR manipulation issue. Your lordship has heard the OMR issue. Your lordship has heard rank jumping. Next page, page 94. My lord has heard expiry of panel, and my lord has heard beyond the advertised post. I am nowhere, completely, unqualifiedly untainted. Para 19. In fact, the High Court acknowledges in para 329 that the percentages of manipulated illegally appointed persons across the categories other than Group D are on a reducing stage. There were no other information available before the High Court. It's only the High Court which has done it first. Nowhere have I been touched earlier in any. Now just 2 minutes more. Item para 3, big Roman 3. Under that, High Court makes no effort to separate the tainted from the untainted. Comes straight to para 22. Para 22. The High Court, this is a blanket approach, throwing the baby out with the bathwater. Completely blanket. The High Court proceeded with option C. C is the cancellation of the entire selection process. Your lordship, I would say, are obliged to do B if your lordship finds untainted categories the High Court did not do, is my humble submission. The only reason to cancel the entire selection according to the High Court is because it is difficult to separate the chaff from the wheat. That's the main reason given. However, no effort is made by the High Court to separate the tainted from the untainted, despite abundance of material available. In Kalon's case, this court laid down a standard of absolute impossibility. I've given that at page 40, para 43 of the judgment. Only in case of absolute impossibility. Convenience is not a defense. Careers of 10,000 in my class will be spoiled, and the answer can't be it's inconvenient to separate or segregate.
Yes.
Then, 24, the aforesaid list provided by CBI and the board have not been adverted to. Well, if the High Court is passing a blanket order unseating me, then it had to at least say that list 1, list 2, list 3, list 4. Where are you, Mr. Singhvi? No exercise, Para 25. In para 325 and 336, there is a whole bunch of paragraphs. High Court holds that the original OMR sheets are not available with the board, and therefore an exercise of sifting the grains is not possible. Is it somebody's fault? Is the original not available? You have enough material from the CBI. How has the CBI made the list, then? How has the board made the list? They could 10,000 you get out because we don't have the original. That can't affect my career, I'm completely outside the system and completely blameless, Then, in para 29, I've dealt with Kalon's case, which I've already made. I'm not reading it, Along with Kalon's case, I've given 3 more judgments, If you all, as a matter of fact, it's a grave miscarriage of justice. Your lordship has material to not punish the innocent. You will not blanket, club me with the guilty and throw me out. That's these 3 judgments, Kalon is the 3-pronged test. It's very important. Your lordship juristic principle is the 3-pronged test of Kalon. 1, 2, 3 I have given. I'm not reading it to save time. The 3-pronged test is very clear. The High Court doesn't apply any of this 3-pronged test. And then lastly, is para 33 onwards, where it clubs groups C, D, and everybody else. Conclusion says this. Your lordship is going to be allowing a very grave injustice to be perpetuated if this kind of clubbing and blanket approach is allowed. You're here, fortunately, you have an individuated approach. Yes. Lastly, one thing, only one minute, only less than a minute. Para 30, I forgot to read this. just note 30. That's the 4 lines of 30 are very important. There are no findings in this regard as far as the majority of appointees being involved in the so-called illegality.
No, that's irrelevant.
No, next sentence. As far as teaching staff is 8% and 14% are found.
That's not the point. The argument you're raising is until it's malafide or attached to me, that's the argument you're raising.
That's the basic argument. I'm not at all involved in anything.
That's a separate argument. Even if we are not able to, that's an argument, even if we are not able to bifurcate the tainted and untainted, then even apply the principle that if I'm not involved, then protect me. That will be difficult to accept.
Mulad, I just, one second.
List of tinted candidates, my lord. List of
I'm
all.
appearing in 1.1, Mulad.
Even if you're not, if you accept the argument, that in all cases where there's gross irregularity or not gross illegality in appointment, and you're not able to segregate the tainted from the untainted, you will have to.
No, but the first objection is that there is a material to segregate. The 3 lists are there. Those 3 lists are there. What else do you need to segregate? Whereas in 4 years, would the CBI put me in some list? Would the board put me in some list? Would the SSC put me in some list? Whereas I can't prove a negative list. They've been doing lists for the last 4 years.
Just I'm appearing in 1.11. I'm in the same category as Dr. Singhvi's client. I just one small submission break. It'll take 30 seconds. And that is that the CBI has got the material from the hard drive. Having got the material, they have segregated themselves because they have said that 92% in 9 to 11 are not tainted, but 8.24% are. And as far as 11 and 12 is concerned, 14.57 are, 86 are not tainted. So the CBI has done that exercise. And having done that exercise, then we can't be punished. And I'm in the same category. And the writ court, what it does is it takes C and D category, the other category where it is 30% and 40% tainted, and clubs it together. Instead of the 19,000 people, 8% or 14%, take an average of 12% are tainted. You will throw out the other 88% because 12% are tainted.
Please, on that based on difficulty, we have understood the argument because the CBI itself has bifurcated.
Correct.
I am in the same category, my lord. I am in the same category as that of Mr. Singhvi and Mr. Sibal, my lord. Only difference is Group C and D I represent, my lord. My SLPs are right on 1.5 and 1.13, my lord. My submissions are at page 100, volume 6A. But my submission is that, like your lordships have noticed, from para 288 till 309 of the impugned judgment, the High Court has taken note of the segregation information that has been given. In none of the reports that our names have figured. We have been appointed in the first list in April 2018. From then, there is no material, nothing. Till the impugned judgment, we have not been called upon to do anything. Our name is not mentioned anywhere else. Now the point here is, if the High Court holds that the information is admissible and we have got enough information to segregate the names from the tainted ones from the untainted, and if this kind of direction at page 272, para 363, the direction number 4 will say that persons who had been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR but obtained appointments, must return all remunerations and benefits received by them in the state exchequer along with interest, etc. My lord, if this kind of information can be taken and their appointment can be set aside with the same kind of information, my lord, how can the item 2 order can be passed, my lord? All appointments granted in the selection process involved is violative of 14 and 16, so all are declared null and void. So this direction, number 2, my lord, cannot stand because there is enough material with the CBI and also, my lord, in all the affidavits which are placed before the High Court, which your lordships have seen. And secondly, my lord, like Mr. Singhvi was pointing out, my lord, Interpret Singh column really says, my lord, there are 3 tests which I have extracted in para 2.3 of my submissions, which exercise has not been undertaken by the Honorable High Court, which says, not just I'll read this. If the services of the appointees who had put in a few years of service were terminated, compliance with the 3 principles at the hands of the state are imperative. That is, to establish satisfaction in regard to the sufficiency of the materials collected so as to enable the state to arrive at its satisfaction that the selection process was tainted as far as them. To determine the question that the illegality is committed, go to the root of the matter which vitiate the entire selection process. Such a satisfaction as also sufficiency of the materials were required to be gathered by reason of a thorough investigation in a fair and transparent manner. Whether the sufficient material present enabled the state to arrive at a satisfaction that the officers in majority have been found to be part of the fraudulent purpose or the system itself was corrupt. None of these, my lord, have been carried out. And para 93 says, it is one thing to say that having regard to the nature of the selection process, no person is appointed from the select list as no person has a right to be appointed only because his name appears in the select list. But in our opinion, a different standard must be adopted for terminating the services of the officers who had completed about 3 years of service in that case. Some of them, as noticed herein before, passed departmental tests. Some have been given higher responsibilities. They had completed period of probation and some were nearing the completion thereof. They presumably had been working to the satisfaction of the authorities concerned. Same here, my lord, from 2018 we have been continuing in Group C and D.
no action against us, not till date, no names have come out, Lord. We have all altered our position in the society, we have improved our lives, Lord, and lifestyles have changed, and we have, some of them have entered into family and not created loans, etc. Their rights will have to be protected since they have not been, Lord, a part of any of this. Even, Lord, in para 2.5, Lord, at page 100 of volume 6A, the judgment in Rajesh Putanvali Kava will say that, Lord, is of significance. If somebody submitted, it's not a case where massive fraud is said to have permeated the entire process since its inception or in the conduct of the examination itself. Furthermore, the untainted candidates, including the petitioners, stand to lose their job after having worked for 6 years without, compliance of 43.
My lords, I appear for the.
That was a bad complaint.
My lords, I appear for the.
There is I one day break. Lord, just one thing, para 3.3.
My arguments have been raised, not only
Lord,
small
this will give.
there.
I have understood your argument.
My lords, I appear for the.
Since the material is already
My
out.
lords, I appear.
At best, Lord, there can be a committee which can be appointed if the Lordship so decide. Lord, I have suggested
Can I say
para
something?
5.1.
I'll not repeat it.
A committee of the retired judge of this honorable court with a technical expert from NIC.
Okay,
Some
okay,
retired
fine.
member from the
Okay,
Lord, I'll take only 1 minute.
Mr. Devendra wants to argue, then we
Not my only, not most of my arguments have been covered, so I won't repeat. My only point was that kindly have just para 3 and 5 and 2 paragraphs of that report, and I'll show you this concept of mismatch which now is the center point of debate here, not is wholly not baseless. Lordship may kindly have para 3 and 5.
3.3 and 5.
3 and 5.
Yes.
Like start from paragraph 5.
Yes.
Investigation has established that the scanning of OMR sheets was undertaken by the said Ms. Naisa Communications Private Limited, W at the office of the SSC, Acharya Sadan, under direct supervision of Shri So-and-so, Niladi Das. Lots of moment, the rest kindly come to 5th line from thereafter. After completion of the scanning,
Yes.
the processed data in the form of scanned images of the OMR scan data, etc., were handed over to Messrs. Data Scantech, handed over by Messrs. Data Scantech Solutions to Naisa Communications Private Limited, who took the same to their office located in Noida in digital form, leaving the original hard copies of the OMR sheets in the office of the Wbssc, handed over their answer keys in respect of all subjects to NASA Communications for evaluation of OMR responses. Now, bear in mind, Lord, NASA was never a party anywhere, nor was it raided ever time, nothing was recovered from them. Now, kindly have para 11, the story of Lord, the comparison. That during investigation, data files containing scanned OMR, DAT files, etc., pertaining to the aforesaid SSC recruitment matters were also seized from Messrs. Data Scantech Solutions. Now, kindly see the conflict between this paragraph and that paragraph. They handed over everything to NASA and they took away. Now, here they say they are comparing the 3 hard disks with the data obtained from Scantech Solutions. Now, again in paragraph, Lord, next page 41, Lord, paragraph 18b. Messrs. Data Scantech Solutions made the initial scanned images of OMR. These scanned images were given to Messrs. Yasa. Pankaj Bansal retained copy of the scanned images now. Now, Pankaj Bansal, not at this point of time, was not the employee of NASA. He seems to he had left NASA and was poached over by his supervisor Niladi Das. Now, where does this come? Kindly just for a moment, Lord, at page, Your Lordship may compare it with the first report. Look at the difference in the first and the second report. Not first report also comes post Lord detection of the 3 hard disks. 3 months after that. And there they said, Lord, paragraph 5, only page, this is paragraph 253. So, Lucia, what were they matching with? Lord? Can we have, Lord, paragraph 5 at paragraph 253?
That Bansal had with the other one. The Pankaj Bansal has the photocopy of the original, scanned copy of the original OMR sheet. The OMR sheets over here are different from what we had initially.
Not the OMR sheet, all the data. It says all the data was handed over.
Correct. Because the OMR sheets is the data.
No, not only OMR sheets, but then there was a tabulation with the answer keys and so on and so forth, not all that. So all that data was handed over. Now, if thereafter it was handed over, then what was seized from Messrs. Data Scantech?
The Data Scantech is seized
That's the reason why.
The 3 hard disks which has the OMR sheet.
No, that's what I'm trying.
Scanned copy of the OMR.
What I'm trying to tell Your Lordship is not. If Your Lordship would have the first report.
The suggested or the correct answers were always available. They could have easily scanned it once again.
Correct answers were available, but they were not with Scantech. I can understand if they had raided NASA and NASA was there.
The NASA didn't really do anything. NASA also they got the.
But what I'm saying, Pankaj Bansal data is being compared with Scantech.
There is the Fulida and
over the whole theory of mismatch. This is what I'm saying. What were they matching with? If they don't have the original, they can't possibly match.
Well, let's item 1.38. I represent the All Bengal Blind Teachers Association.
There are 18 blind teachers, totally untainted. But the two additional points is one, Soma Das was equally visually challenged. She's been exempted at paras 360 to 362. We should stand on the same footing. The second is there are persons with disabilities.
Something in addition to that, some humanitarian grounds she was given an exemption.
That's right.
Not just because she was blind.
No, not just because.
In some other circumstance.
No, but we are totally untainted. We don't figure in any of the lists. There are 18 of us.
If we gave it in that way, it will become very difficult.
No, but
then we're creating a new category altogether.
No, it's no new category. The Great Resistance, the High Court has recognized that Soma Das is visually challenged.
If they probably
No, may I just point out two more things. Persons with disabilities.
We understand, but there will be others who would have also in your category who may not have been.
No, all your lordships will have to see is, do they figure in any of the lists at all? No, and the other thing,
You want to accept that? I think we all accept it across the board.
No, may I also say this. 4 of them were in service. They had applied for these exams for upgradation.
That will take care of.
Well, the third aspect, many of them were given age relaxation because they belong to PWD category.
We take care of that.
Very well. That's all.
May I mention, in this particular case, the certificate...
Only two things, Lord. There is an exam conducted. There is no taint for the exam. That is number one. So the exam results are given. There is no question.
There is a taint for the exam also.
No, there is no
because
taint.
Marking is part
No, marking comes later. I am coming to that later, Lord. So there is an exam conducted. We are all appointed. We are the ones who are untainted. So there is no issue with our appointment. We continue in appointment. Because of the Bansal Lord raid, a hard disk is discovered. I'm part of the untainted. A hard disk is discovered. So there is an issue with regard to some people whose marks have been altered. Otherwise, Lord, there is no way of identifying, Lord, those 900 and whatever. Because the identification only takes place because they find that there is an alteration. Obviously, Lord, the sequel to that is that for the others there is no alteration. Because if there is no other alteration for the others, Lord, that is why, Lord, they are not found in the tainted category at all. Now, Lord, last thing. If there is a taint which can be said to be such, which may be across the board, which is not possible to be discovered, then if your lordships have held in some judgment, then the whole exam has to go. But if the taint is such, where the basis of the taint itself is showing alteration of some people's marks, then that can't apply to people whose marks are not altered. So my respectful submission is, Lord, as far as we are concerned, we are doing our job for the last 6 years. There is no taint as far as we are concerned. Our marks are not, Lord, have been a basis of finding somebody whose marks have been altered, or somebody, Lord, who has been given a selection who was beyond, Lord, in the merit list. So there are two categories of taint. One is, Lord, whose marks are altered. The other is people who are lower in the merit list and inserted into the merit list. Both those categories are identified and both those categories are put in the tainted list. We are in neither. So there is no question of, Lord, our appointment being.
Let's in 188, Hitesh Ghosh.
My candidate, Lord, I represent 150 candidates who are already in government service for past 10 years. I participated in this selection process, Lord, got selected, got appointed. I'm still in service. I'm untainted, Lord. Lord, we should be treated as a separate class, Lord, to be protected. Lord. That's all I want to submit. We are all in service for last.
I appear for the 148 persons. Now that is comprised of some visually challenged persons, some persons who were already in service, and all are untainted. Well, I only want to refer to paragraph 362 of the impugned judgment. Their High Court, my lord, I don't say on a very reasonable ground, took an exceptions on the ground that there is a medical condition of a girl, namely Soma Das. In her case, an exception is carved out. Now, so far as we are concerned, my lord, we are only praying before your lordships that the fundamental principle, my lord, all judicial system that is being followed, like one hand, your lordships try to ensure that no illegality is perpetuated, no difficulty for that. On the other hand, if lordship finds that we are the honest and the innocents, we are the victim of the situations because we are completely non-tainted, and that too in a judgment and humanitarian aspect has been incorporated. My lord, since we are completely untainted, lordship may carve out an exception as far as we are concerned. But this is my fundamental submission.
So let's see, Hitesh Ghosh, 1.88. Let's can I see the
I made a note also, my lord, at page 94 onwards.
Certificate of 2022, which is the foundation of everything, itself raises a large number of questions which impacts the entire category. So I am untainted, no name anywhere, but the fact remains is the certificate is being given by one Pankaj Bansal, who does not have the legal authority nor the legal capability to give the certificate under 65B of the Evidence Act.
Why?
For the very simple reason that he does not fulfill the conditions under 65B.
No, it is not required. In his case, the CDs were, the hard disks were recovered from his residence. He is the one who is in control of it. He says in the 65B certificate, these are the hard disks on the basis of the scanned documents. That's all.
I pause for a minute. Now, the issue.
65B really is not required in this.
With utmost respect, if he addresses the entire issue of the certificate of 65B, then the entire controversy will be standing settled once and for all. Because the question is, the original data belonged to West Bengal Commission. The commission asked NISA. So at best, there are only two legal entities.
If he's the one who had operated and you had taken that, who had operated and scanned the machineries, this certificate will be valid.
But with the utmost respect, when one reads to the certificate, there is no reference to the conditions under 65B4. Also, Millets, it's nobody's condition or nobody's case that he was the one who was.
65B.
Millets,
We need not apply.
Millets, I am only on the limited point, I'm not even 65B, on the limited point of the certificate. Because the certificate is being given by a person who does not have lawful authority over the original computer records. The original computer records were with the.
He's the one who has the hard disk.
Millets, he's a thief. The question is, he's only a thief. He gets unauthorized access. Millets, at the end of the day, it's something like somebody come and steals something from my house, and I find something is found here.
Yes, he will be. And in this case, 65B really speaking is not required if the original hard disk is there.
Millets, the question is, there is no original hard disk.
That's been clarified even in Anwar versus machines. It doesn't apply to.
Millets, when I go to Arjun
there is a
Pandit,
contradiction emerging. If one looks at it careful, there is a contradiction emerging.
Millets,
because 65B is if it's a notwithstanding clause, non-obstanding clause, it will override the primary evidence. But Anwar versus Bashir says that 65B will not apply to primary evidence.
Millets, in this particular case, when I come back to Arjun Pandit Kotkar, what they are saying is that this is a complete code.
That follows that, unfortunately.
So, Millets, in this case, when you look at the certificate does not say how does he get custody, number one, because this is.
Because it's in his possession.
Millets, what he's in possession is not the original. What he's in possession is also not a copy. What he's in possession is tertiary evidence, which is not the consideration under 65B of the Evidence Act.
Yes,
Also, Millets,
1.64 and 1.67. We are from fourth category. We are not in tented category. We are clean. We are appointed in 2018. Still we are working very nicely. Not a single blemish towards us. But unnecessary, Honorable High Court has quashed. High Court has initiated re-examination and everything, reprocessing. So, Lordship, kindly exclude us from this.
Okay, fine.
Yes, Lordship, can I become 1.37?
The moldings are I'm on Para 3.95. The High Court has asked for fresh selection. All I am requesting is, my lords, if my lords are not with us on the aspect of that, despite us being untainted, we should be selected based on the previous selection. Then, my lords, one is an age relaxation because this only goes up till 40 years. Now, 10 years have gone by since the last examination. Second, my lords, that I'm requesting is, my lords may consider to restrict the examination to those people who had taken part in the first examination in 2016. That is all I'm praying, my lords, in modification of Para 363. So great.
May I with your lordship's leave, my lord, item number 1.110 and 1.185, my lord. I would, my lord, take cue from the submissions made by Mrs. Dr. Singhvi and Mr. Sibal, my lord. And I would only highlight, because most of the submissions which I was supposed to make have been covered, my lord. Lordship will kindly take paragraph 312 of the judgment, impugned judgment, once, my lord, and the possibility of exploration with regard to Roman 2 is the segregation. Now, where I stand, my lord, I am the candidates who participated and are not called for verification. Interestingly, my lord, there is what I understood from the understanding of the segregation part. So far as, my lord, the affidavits filed by the School Service Commission, there is an unequivocal admission from the School Service Commission with regard to certain irregularities with regard to rank jumping and etc., which has been enumerated prior to my submissions, my lord. My lord, taking a cue from that, my lord, if there is such irregularities which are apparent on the face of the record, my lord, and there is an admission which is unequivocal, my lord, my understanding, my lord, subject to the lordship's corrections, my lord, nothing remains beyond that, my lord. That irregularity can be rectified at the threshold, my lord. That is one limb of my submission. So that rectification would entail Roman 2 to be implemented to the extent that the tainted and the untainted can be divided. Now, once that division happens, my lord, my role comes into play, my lord. Once the division happens, the tainted goes out of the system, my lord, and the system provides for 1:1:1.4. So for one vacancy, 10 people, a list of 14 will come. If a list of 14 comes, and in the list of 14, there are tainted and untainted, I'm not in that list, and my mark is below that 14, may say, for example, I'm 16, 17, and 20, and not within the first 14, and it is found out within the first 14, 7 are tainted, and the segregation can happen. So I automatically, the category of marks will go down, and I automatically come in.
Not even in the running.
Technically, yes. I absolutely, Millet, I understand, Millet. But, Millet, I would conclude in one line, Millet. In a highest court of this country, Millet, the situation is such that there is a possibility of a segregation, and if that happens, my lord, once, my lord, the SSC has, my lord, applied Rule 17, they have technically set the clock back, my lord.
I know it's a problem of plenty, but quite a few submissions.
Deeply obliged.
Just two things I wanted to highlight. We are from classes 11, 12, appointees to 11 and 12. The OMR sheets were never published. This is something where, my lord, in my respectful submission, goes to the root of the matter. Where what is it that we are looking at which says that there is a manipulation and that the marks have been manipulated? Absolutely nothing is made available. During the process of proceedings before the High Court, my lord, inspection was made available for a limited time of 1 day or 2 days. So some persons took inspection of that. That's one, my lord. Therefore, when there is no publication of the so-called, my lord's, OMR sheets, from where does all of this come? That's one. Second, my lords, admittedly, there is a criminal prosecution which is launched, which is pending consideration, pending adjudication. It is one thing to say the standard of proof in criminal proceedings is higher and therefore whatever may be the result. But the substratum for both, my lords, is the so-called manipulation, my lords, in the mark sheet, OMR sheets. If that be so, please see the anomalous consequence if that results in no conviction at all. Or for that matter, no evidence is given by the so-called Pankaj Bansal. So many other such consequences. That's the second point, my lords. Third, on 65B, my lords have again and again pointed out, I quite see the force of it, saying that it is only a certificate of the fact that it's a printout from a system. That's fine, my lords. What evidentiary value to be given is a different aspect altogether. I'm on something more fundamental. Now, it is not the hard disk from which, my lords, the original scans were available. That is something which is not there at all as a fact which has been established. It is a hard disk which has been, my lords, taken from a private person who was an ex-employee, my lords, of NISA, and the manner in which this has become available to him or made available to him is completely shrouded in suspicious circumstances. If that be so, my lords, can it stand to reason that on this basis, extreme penalty, my lords, of removal from service can be done? And of course, the fourth aspect, my lords, is the segregation, which has already been highlighted by others, my lords. I'm obliged.
Lordship, I appear in item number 1.37.
Lordship, my lord. Lordship, may kindly, my lord, this order has previously been placed, my lord. May kindly comes to the order dated 5th February 2024 at page 1014 of the compilation, that is volume 3. Here, my lord, the hard disks, these were produced. And kindly sees what was the reaction and what was the direction which has not been followed by the CBI. Well, kindly comes to 1014. Well, this is the recording of submissions made by the learned Deputy Solicitor General. He seeks leave of the court to file one such original through an affidavit. He also submits that the original electronic devices seized were sent to Central Forensic Science Laboratory at Hyderabad, who have returned the same. The original electronic devices are presently with the CBI and in fact brought to the court today. He submits that the CBI intends to place those electronic devices with CFSL Kolkata for necessary processing. He seeks direction to the court with regard to the production of original electronic device seized. Now, Mala kindly sees the direction which has been given by the Honorable Division Bench, 1016, last paragraph. So far as the prayer of the Deputy Solicitor General is concerned, with regard to the original electronic devices are concerned, it would be appropriate to permit the CBI to produce such original with the CFSL Kolkata, where they propose to submit the same for necessary processing. As of today, there is nothing on record as to what is the result of CFSL Kolkata. It is not there on record. Second is, Mr. Thereafter, my lord, proposed to submit for. Now, my lord, kindly see the last part where there is my lord, a direction. Kindly comes to 1018. The original electronic devices are produced by the CBI pursuant to the order passed by this honorable court. According to CBI, such original devices are required to send to CFSL. This is to CFSL Kolkata. There is a criminal proceedings pending. According to CBI, those electronic devices are required for such criminal trial also. In these circumstances, we deem it appropriate to record that the original electronic devices are produced in seal cover. They are returned to the Deputy Solicitor General with the direction upon the CBI to produce working copy of electronic device prepared by CFSL. This was never produced. Now, my lord, these are the 3 hard disks on the basis of which allegedly the OMRs have been retrieved from these hard disks. These were the only materials before the court, if produced, could have been from the basis of, my lord, our target.
Okay, let's.
Lordship, 1.37, may I just amend? Lordship, there is a distinction. Lordship, in 1.37, there were orders by the High Court. And this is 1.37, if I go to volume 2, that is annexure P1. So there was one question, which was where the answers were re-examined by the High Court and our answers were found to be correct. So after the School Selection Commission and also the single bench, we were genuinely appointed. So our appointment has been also cancelled by virtue of the impugned order, which is because a few candidates or 8,000 candidates were found to be illegal appointees. We were genuine appointees, Your Lordship. It is mentioned by the single judge's order in volume 2 at page 45 to 448. 445 to 448.
Volume 2?
445 to 448. If I can just, aspirants and participated in the first state level selection process 2016 for the post teacher history. The final merit list was published on March 12, 2018. Subsequently, pursuant to a direction made by your coordinate bench, the West Bengal Central School Service Commission had published the OMR answer sheet of the aspirants on their official website. From such publication, it appeared that the petition...
Can you read that sentence again?
It's volume 2, Your Lordship.
No, read that sentence once again.
The final merit list was published, this sentence, on March 12, 2018. Subsequently, pursuant to a direction made by your coordinate bench, the West Bengal Central School Service Commission had published the OMR answer sheet of the aspirants on their official website. From
Was all the aspirants' original OMR sheet published on the website?
No, Lordship, it is, I represent 27, so I can only speak
There
for
were
the
only
petitioners.
27 which were published, or all of them were published?
There's no specific mention in that report.
But-
we have to from 11.
but-
That's not been, you never argued that before the High Court.
No, Lordship, it was, this point was, we have submitted a written submission also. I'll show it from the High Court order. So this one, it was our answer which was found to be correct. If I just read out that from such publication, it appeared that the petitioners opted for the answer option B, which according to the said commission was also the correct answer. Accordingly, the said order dated January 4, 2023 stands corrected and clarified. Now coming to the court dispute in this sense.
When did you file your writ petition?
We were the writ petitioners before the single judge and we got appointment by the orders of the court. So Lordship, my request is that there is a blanket order by the High Court. I should be segregated.
Okay.
Obliged.
My lord, may I just submit?
I am done it with
My lord, I mean, for Group D, my lord. Only
1 minute is very long.
Lords, may I just make, I have two sets of submissions, I'll be very brief. Now I'm on the first set. The first set of, I'll try and anchor it on a principle. The first set is for untainted, for the untainted category of assistant teachers. We represent 10,160 teachers. Now, Lords, here I want to invite attention back to paragraph 240 of the impugned judgment, which your Lordship will find at page 210. 240, 210. Now, the High Court itself records that in the assistant teacher category from class 9 to 10 level, the alleged irregularity is for 8.5%. And as far as classes 11 and 12 are concerned, 14.47%. So obviously the group which I represent is part of that untainted category. Now, my lords, our respectful submission is twofold really, that the essence of the judicial function is to separate and to confine the operative directions to likes. You cannot, my lords, in my respectful submission, 10,000 teachers over here, each one in harness, nothing found against them, and even so you just throw them all out with this kind of percentage. Now, therefore, your lordships have provided guidance in two judgments. So I'm just going to give your lordship the citations. They are in my written submissions. The first is Indrapreet Singh Kalon.
That's been referred to.
Yes, it's been referred to 2006-11 SCC 356. Para 41 is the most important, but there are other paras also. And the second is Onkar Lal Bajaj, 2003 2 SCC 673, where the relevant paras are paras 44 to 46. Now, let me just summarize what those judgments said, at least on our understanding. Lords, the first point in our respectful submission as far as Kalon's judgment is concerned, where all the judicial appointments, etc., were set aside, this court interfered and reversed. Why? Because you can't have, because the principles laid down were that there's a difference in situation, say, for just an exam, where people haven't passed or are, and you cancel the exam. It's very different when people are employed and are in harness because you have jobs, you have families over here. So if you have 10,000 untainted families, the question I ask myself is, where is the question of cancelling these? Now, therefore, this court has laid down the principle. One, if you have situations where people are already employed, this is para 41, then you have to see sufficiency of evidence. So it's an admitted position that as far as the untainted are concerned, there's no evidence. Arguments are all are different arguments. They say those are also do not amount to evidence. But in the case of the untainted, there is absolutely no material before the High Court. Now, if you have no material for the High Court, and if you have situations such as you find that in some cases there is some people have leapfrogged, other situations, some panel, some OMR who are not found, then the final operative directions ought to, in our respectful submission, that's the judicial function, confined to those types of cases alone. And Onkar Bajaj, your lordship, recalls the entire petroleum allotments of petrol pumps were set aside. And this court said that's completely over-inclusive. Because if there is some wrongdoing in certain situations, You have to remedy that. The remedy has to be tailored to the situation, to the wrong. You can't have a solution which is worse than the problem which the court was encountering. So this, my lords, is my first set of submissions. The second set of submissions, my lords, which I'm making is on another fundamental principle. I just state the principle. The lordships have heard us. The principle is essentially this, that under our system, if you're losing, my lords, your jobs, then I believe we are entitled to one right of appeal, which is why your lordship is hearing us. Now, on this aspect of appeal, I want to give your lordship 4 or 5 dates. So I've just put it on a sheet of paper. This may be just handed over. Now, this is, my lords, I'm now not an assistant teacher. This is the second set. I'm just going to give you 5 dates on one aspect alone, because this group which I represent, which is Group C candidates, which are non-teaching staff, although successful, they have been branded as having been appointed after the expiry of the panel, correct? So I'm just making my submission. Please just go to paragraph 6.
Yes.
In particular, the finding of the petitioner's appointment were after expiry of the panel is erroneous. The panel is defined in section 2F of the 2009 rules. In the present case, the panel was declared, now note this date, on 20th June 2019. This is the first date when the candidates with all their particulars were ranked and a list was published region-wise. An illustrative extract of the panel is set out below. So please note this date, 20th June 2019. In terms of Rule 17 of the 2009 rules, the validity of a panel is 1 year. In the present case, the panel was published on 20th June 2019 and the recommendations for the appointments have been made between December 19 and March 2020. I'm sorry.
This will be after grading supernumerary posts.
No, this is not a supernumerary situation at all. So our respectful submission, I'm just saying what a court, just see the para 10. There was a High Court writ petition. The High Court said publish the panel. That is where you got 20th June 19. And my appointments were all made within 1 year of 20th June 2019. There's a finding of fact which is in error, where they have taken a date prior to 20th June 2019, on which date there was no panel published at all. So the first and only date
When
for
was the
reckoning...
result declared?
Sorry?
When was the result declared?
Yeah, so the result, so I'll just indicate. So the result was earlier and individuals had access, but there was no panel.
No.
Because the expiry of the, but that's the basic.
The date of result will be.
No, date of result is, it's date of panel. Because expiry of panel.
What should be done? Should we have it tomorrow?
But I may keep it on reopening. They get a chance to look through our written submissions which are detailed.
Can you take up tomorrow?
They are in India infimortal. This process they continue for more than 2 years. All fraud appointees.
As item number.
That it should be the item number 1 as a continuing.
Please. Not your matter.
May I seek your lordship's indulgence?
Item 44.
Item 40, which your lordship had kept today, where the award, the repatriation had to take place, hasn't taken place. Despite your lordship saying we'll summon the directors and the contempt, could it be tomorrow, my lords? Because your lordship specially kept it today. Where your lordship directed 1 year back, and then in May said we will call the directors and contempt will be initiated.
Just give a clear.
Milord, on 7th, Milord, there is another big batch matter, Milord, which has been fixed.
I was just going to
State of West Bengal batch matter, Milord.
There is some
in the OBC.
Please give a date, clear date on January.
It's in a different court, Milord. Milord, your lordship can, of course, Milord, take care of it. Yeah, all
my lord, consider.
My lord, may I just submit? My lord,
This matter is the passport on.
my lord, may I just...
Then can I request for the 10th of January, my lord? Okay. 10th of January on the top of the board, my lord, because your lordship's order for 1 year has not been honored.
Item 42 has some urgency, my lord. Your lordship give it date. But it is a CIRP matter, where CIRP process is permitted to go on subject to result.
My lord, may I just submit one?
January. I'm asking for actual date January.
No, it's made on board. January, let me put it down.
It's 42 today.
Let me just, Thursdays will become a regular day now. Thursday, Tuesday, Wednesday will be maintaining.
I see.
So this will retain its
But
position.
we're going to be circulating. There's some work which has been done with regard to the after notice of regular matters, along with the office store. A brief note about the case will be there.
I see. Milord, 42 is lower in the list. Milord, can we request for your lordship?
Grateful, man.
Just quite on the visit date fixed.